Close Planning and Zoning Committee, or Council, Commission to order. We have a roll call, please.
Chair Lip,
Present.
and it's been noted that Vice Chair Crawford will be late. Let the record also reflect that Committee Member Corning is not present. Committee Member Harris.
Present.
And Committee Member Joyce is also not present. Have you heard from her?
I've not, no.
Alternate Member Close.
Here.
And Alternate Member Yan.
Present. Guillaume.
Guillaume.
Let the record show that the two alternates will be voting this evening.
Thank you.
Okay. Going on with the agenda, let me catch up here with the agenda open. And we had a revision on that today, so I'm opening up the agenda pack. And is there a minutes for signing, by the way, that I can take care of today, or? We need to start out with the oath of office, right? So I'll turn it over to Town Manager and Town Attorney.
Town Attorney will swear in.
Thank you, Mr. Chair. Member Guillaume, please raise your right hand, and what I'll do is I'll ask you to state your name and read the oath, and you say whatever you're comfortable saying at the end to affirm your acceptance of the oath. I state your name.
Burns Guillaume.
Do solemnly swear that I will full and faithfully perform the office of Planning and Zoning Board Member for the town of Waxahachie Grove, that I am qualified to serve the office about which I'm about to enter, and that I will fully adhere to and honor the Constitution of the United States, the state of Florida, and the laws of the town of Waxahachie Grove, Florida.
I will.
Thank you.
Welcome aboard.
Thank you.
Okay, we've got the oath done. And has everyone had a chance to read the minutes from the December 13th meeting? And could I hear a motion for approval?
Yes,
Committee Member Alternate Close moves for approval. Is there a second?
I second.
We'll take a second from Alternate Burns Guillaume. All in favor, all opposed, motion passes unanimously 4 to nothing. Old business, the site plan approval. At this point, I'll turn it over to staff for a presentation of old business.
Okay, thank you, Mr. Chairman. The project before the board tonight is the Valley Crest Magic Site Plan approval. The application was originally presented to the board back at its meeting in November, and the board had several questions regarding how the project was to be reviewed and how it was to be processed, and on that basis continued the hearing to December, and it was ultimately continued again in December to today's meeting. The extra couple of months gave the applicant and staff an opportunity to sit down and fine-tune some of the details of the application and the site plan and the proposed conditions of approval, which are part of the package tonight. So with that as an introduction, I'm not going to go through quite as detailed the presentation as I did in November, but I think the presentation will certainly hit the highlights and the key points and staff conditions, recommended conditions. As I said, the project is Valley Crest, and with us tonight we have Harold Worthington from Magic Properties.
If I could interrupt you for a second, let the record show that Committee Member Grace Joyce has arrived. Sorry.
Okay, so we have Harold Worthington to my immediate right, who is representing the owner of the property, Magic Properties. 5 LLC, and also David Coviella to further to my right, who is the agent representing the project. The parcel is located on the south side of Okeechobee Boulevard, approximately a quarter-mile west of F Road. It's a 5-acre parcel. Current land use designation is rural residential 5, and the zoning designation is AR, agricultural residential. There's an existing use on the property of a landscape maintenance business. The property currently has no approvals for the use on the property, and the proposed use is a principal use of wholesale nursery and accessory use of landscape maintenance business. The primary reason that the project is coming before the board tonight is due to a citizen code enforcement complaint which was filed back in 2008, at the time when the Palm Beach County Unified Land Development Code was in effect. The town didn't adopt its own code until November of 2010. And the fact that the code violation came into effect under the county's code is the principal reason why this particular approval has become so complex and complicated. The subsequent to the notice of the code violation, it went to the town's special magistrate, and he issued an order saying that the property had to come into compliance with the code that was in effect at the time of the code enforcement complaint, which was the Palm Beach County Code. So we're sort of saddled with the task now of going back and evaluating and either approving or denying a site plan under the land development regulations that were in effect in Palm Beach County as of 2008, as opposed to the town's current land development regulations. The issue is further complicated by the fact that under the town's current code, a landscape maintenance business is specifically prohibited. If the application were to come through under the town's code at this time, that the current use on site could not happen. However, since the county's code was in effect, the special magistrate has allowed the application to come through with the principal use of a wholesale nursery and accessory use of the landscape maintenance business, which was allowed if approved under the county's code at that time.
Now, was the definitions that was in the county's code the same as what you're referencing on? I'm just going off of what you handed out. I guess it would be on page 22 of the PDF. Use definition, Palm Beach County ULDC, accessory use. A permitted use that is customarily associated with the principal use and clearly incidental to the principal use and is subordinate in area, extent, and purpose and serves only the principal use. And then the Loxahatchee Groves ULDC goes into accessory use, and its definition is similar. Let's see, and then it just goes a little farther. Accessory use, a naturally and customarily incidental, subordinate, and subservient to the principal use of the premises, and located on the same plot as the principal use. The area of accessory use shall be subordinate to that of the principal use. So it's essentially the same.
Yes. And on the face of it, you might argue that a landscape service business doesn't necessarily meet that definition. However, At the time of the initial code violation, the property owner went to the county with a zoning confirmation request letter stating, can we put together a site plan application with a wholesale nursery as a principal use in a landscape service business as an accessory use? And the county's response was yes, you could do that. So the county.
Where is it? Do you have that documentation? It's in, okay, yeah, sure.
Yeah, I mentioned it here. I have the documentation in my files. So based on the county's interpretation of that definition, it is appropriate to make application for the principal and accessory use that we have in front of us.
Also, let the record show that Vice Chair Robin Crawford has a right, and the second, I guess, Mr. Burns-Guillaume will no longer be a voting member tonight. Grace?
Happy New Year, everyone, and I apologize for being late.
You're here.
Yes, I'm here. I just have, for clarification, Jim, according to the staff report, it says that the special magistrate ordered that the applicant come back and comply with Article 4, blah, 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 of the Palm Beach County ULDC. Is that correct?
Yes.
So the special magistrate said that they had to comply with whatever the standards were back in 2008.
True.
But what they're asking to do is not what they're currently doing, because they're still just doing the landscape business. I drove past there today. I don't see any wholesale nursery on site. So I'm asking then, the application that's before us is not what the special magistrate instructed in remedying this problem. I mean, they were supposed to come back to try to rectify the situation that was at hand in 2008, which is a use that was permitted with the exception of the outdoor storage of the debris. Is that also correct, based on what's in the packet?
Well, sort of a two-part question, I think. The business on site now is operating just as landscape maintenance. The application, which is what the magistrate ordered, was to come back with an application to meet the code.
That's not what this says, though, Jim. I'm sorry I interrupted you, and maybe it's just that what the order says and what this paragraph on page 2, the very first paragraph, says is different. Because if they're supposed to come into compliance with what they were doing in 2008, based on what the county permitted in 2008, then they should be coming forward to us with a landscape maintenance application based on what the county's code permitted. And there are standards in here which you went ahead and cited as part of the Class A special use permit, which talks about the, on Exhibit B1, the Palm Beach County Supplemental Use Standards, and it just lists a bunch of different things, including hours of operation, storage, buffering, and so forth. So based on how I was reading this, it outright prohibits the outdoor storage of debris.
Okay, well, now I guess there's no definition in either code as to what debris is.
Wow.
First of all, and secondly, I guess in this instance, one man's debris is another man's resource.
Okay, but if you're asking us to review this application based on what the special magistrate ordered, I don't think this application meets the intent of what he ordered. the special magistrate did not say add, you know, the wholesale, because I understand what you guys are trying to do, I really do, I get this, you know, I deal with this a lot. And did you, what year was the property purchased in, 2005?
2006.
Six? Okay, so the business was operating illegally for 2 years, then it was cited, and it still did not come into compliance, which there was a vehicle at that time, which was a Class A special use permit. So a zoning letter was issued on the request of the property owner to say, hey, if we come in this way, do we still have to go for a Class A special use permit? And the answer was no, you don't. And at that time, they still didn't apply to get the correct licensing, which they could have, because if the county issued a zoning letter saying, yes, you can do this that way, then they could have issued their business tax license for exactly what they were doing, which would have meant changing the business from its primary use of landscape maintenance to a wholesale nursery.
Yeah. No, that's-
And still, to this day, it's still not a wholesale nursery.
But at the time of 2008,
Mhm.
regardless of which code they were going to comply with, the application would be made to the town, not Palm Beach County.
Then why was the
And-
zoning letter issued from the county instead of the town?
Because they wanted to get an interpretation of the county's code.
Mhm.
And the best place to get that interpretation was from the county staff.
Mr. Chair? Maybe my recollection is pre-me,
Yeah.
but it's my understanding that at that time, since we were operating under the county ULDC, that we had an agreement with the county
Mhm.
planning department to do plan review. And so when I recently reviewed this matter, I understood that was part of that request, that they had gone, instead of going at someone on the town staff like Jim to give a review, it was directed for the
Right.
county to do it because of that agreement, and that's why it was a county letter interpreting the county's code. I don't know if that helps.
No, I mean, I understand this perfectly, I just,
I didn't know.
Uh,
I didn't mean to interrupt, I just.
Board Member Joyce, may I address it? Okay. The notice of violation that was issued initially was for landscape service permitted only in conjunction with a retail wholesale nursery. That was what the violation was for. And so they cited the county code dealing with that issue. So the special magistrate ordered us to comply with those provisions of the county code. And so that's why we filed a site plan with the primary use as a nursery, secondary use as landscape maintenance. Now, even though under the county code at that time, we were allowed to do a landscape service company as a primary use, as a standalone use. But because we were cited in this way, and because the town no longer permits standalone landscape service companies, we want to come closer into compliance with the town's code. And so we thought this was a reasonable compromise to come in as a primary use, as a nursery, secondary use as a landscape service company. I agree with you that there's not a nursery on there right now, but obviously if this were to be approved, we would install the nursery component. As far as the timeline goes, I know some of the board members were not here from the prior meeting, but I have prepared a timeline, and if you want, I can walk through it. I think that may clarify.
no, I read the minutes from the meeting and the explanation that the town manager gave, but I don't know if any of the other board members are interested.
Love a copy of that.
Do you like a copy?
Yeah.
Sure.
Can we
And that,
have one for the clerk? Why don't we go ahead and put one,
Yeah, if you're
who
handing out
wants it, go ahead and put it in for the record. So it's-
Yeah. Have a motion to receive and file?
I think think this will help address the issue of, it's not a situation where we sat on our hands for years, and I think this will address that.
Mr. Chairman, is the staff finished with their report, or did we kind of?
I don't think so. I think we just got.
No, I'm not, but I mean, certainly we might as well, on this particular one anyway, we can just take questions as we go, because we certainly can get lost.
this is a very complex,
Yeah.
because of the moratorium that we had, and you know, got into business right when the town was incorporated, and so, you know, we understand it's a tough point that you're in. I'd like to hear fully from staff and from the applicant,
Okay.
and then we'll bring it back to the board for questions, so we can just let them finish up.
Okay. So, ultimately, what we ended up doing was making a comparison of the town's land development standards with those of Palm Beach County that were in effect. And we did the staff review based on the application of the county's land development standards, but we did find that in almost every instance, the standards were either quite similar or exactly the same. And I did have there's a comparison of the standards on page B7, attachment B7. And you can see that the lot size, frontage, setbacks, all that kind of stuff are very, very similar. The only difference was in the, well, not the only difference, but the only substantive difference was in the rear setback. Under the town's code, one of the accessory buildings currently violates the town's 50-foot setback. It's setback 47.5 feet. Under the county's code, accessory buildings in the AR district only have to be set back 25 feet. So by the application of the county standards in this instance, that nonconformity goes away. Other than that, the land development regulations are quite similar. Okay. So the staff report includes 4 basic attachments. The attachment A is a summary of the history of the project and how staff came to the conclusion as to how to proceed and which land development regulations to apply in the review of the project. Well, no, I take that back. That's attachment B. Attachment A is the proposed site plan and the applicant's statement of use as to how the property, how he's committing to use the property. Attachment C is the site plan review details. That's where we applied the county's land development standards to the characteristics of the property and came to the conclusion that the site plan meets the county plans. And attachment D, which I would really like to focus on primarily, are the recommended conditions of approval for the site plan. Basically, the staff is recommending approval of the proposed site plan subject to the list of proposed conditions in attachment D. And if I could refer your attention to attachment D, I'd like to spend the rest of my time looking at the conditions of approval.
Mr. Chairman,
Yeah.
if I may interrupt for a second.
Sure.
Perhaps before we get to the conditions, we should flush out all the other issues. And then when we get to the point when we want to make a recommendation, maybe that would be a better time to start reviewing all the conditions. That's just my suggestion.
I concur. So let's start with Veronica, and then we'll work down the board.
You really want to start with that?
I guess so. Burns, if you have something you'd like to start with?
Mr. Guillaume, you can participate, you just can't vote on it.
Okay. First, as to process, I want to make sure that I understand this procedure. This is not a quasi-judicial hearing, as I understand it.
Not tonight, that's before the council when they adopt the resolution approving the site plan.
Okay, then what part of this meeting, this discussion, is considered part of the official record?
All of it.
And how is the discussion conveyed to the town council during its quasi, or how is it done?
I believe it's done through providing the minutes to the town council with the agenda materials that are provided to them that reflect the discussion, the debate, and the ultimate motion that was adopted by the.
And also for a report.
Yeah, it is included, I guess, what happened, also, the staff report you see here that's to you all is updated to have a section on what happened at the various stages of the planning and zoning board. Much like, I don't know if you were able to look at the materials that were provided for the State College thing that went back and forth. It had a chronology. This is what occurred at this meeting, this is what occurred in this meeting, and why things were changed at each step of the way. So staff provides that information to the staff report as well.
Thank you.
Yep.
My initial question isn't to you. First of all, I want to thank you for all the time you spent on a number of months on these reports. This is a very tricky issue, and I think you've clarified a lot of issues. I still have some questions.
Sure.
But before I do that, I would like to ask anyone if they could answer why landscape maintenance was excluded in this district, if anybody has that information.
I was at the meetings, but I don't recall how in the discussion, Mr. Lipp, you were on the council.
I was on the council at the time.
Recollection on?
The primary concern with landscape maintenance operations was the amount of traffic that was generated, the amount of, both from vehicles coming in and vehicles going out. It was decided that a landscape maintenance operation could be done by someone who was the homeowner and the landscape maintenance person. So in other words, a home-based business, with one truck, could be a home-based landscape maintenance operation. But it's as a home business with the primary person doing the business, the homeowner, and homestead. So that was the feeling of the board. So when it comes to commercial landscape operations, my personal feeling is they belong in an industrial zoning area. That's just, we'll get into that discussion later.
When the applicant was cited in 2008, given that he didn't have any necessary approvals, that was an illegal use at the time, is that correct?
Yes.
Okay. He never got any of the approvals,
True.
so still hasn't gotten them. So as of today, it's still an illegal use.
That's
Just
correct.
clarify.
Yes.
Okay. Did at any time the town go back and advise the special magistrate that ULDCs have now changed, Mr. Special Magistrate, so would you please amend the order to require them to conform to the town's ULDCs?
Well, at the, when we had the hearing before the special magistrate, there was a lot of testimony back and forth between the town's code officers and Mr. Worthington. The issue at the time was that, and Mr. Worthington testified, and he can also, I'm sure, add for the record tonight to you, but I'll give you my recollection, was that there was some difficulty. They did have some agreements with Calvin Giordano, who was our prior code enforcement vendor. However, he testified to the magistrate that in trying to track down, I guess there was some, let me put it this way, there were some agreements, but they weren't in writing. There was nothing that Mr. Worthington could give to us to prove it. They were verbal representations he was making, and he couldn't, I think one of the code officers moved to the West Coast and was not reachable, another one was ill and did not want to get involved in any way, shape, or form, so the special magistrate was faced with the issue. There was a large fine on the table, and then there were all the other associated issues with the use in the county and, the moratorium and all the other items. So I think at that point, if a remedy can be found, the special magistrate is going to obviously let the the respondent attempt to seek that remedy if possible.
Okay, but my question is, did the town go to the special magistrate at any time up to today at one of its extension hearings and ask the special magistrate, advise the special magistrate, you've got a ULDC now, Ms. or Mr. Special Magistrate, would you amend your order?
No, why would we do that?
So that they would comply with
So
the
they
town's
comply with the town's
ULDC
ULDC.
instead of the county's.
But that's not the code that applied
Yeah.
when the case was instituted.
Yes, that's true, but it's an illegal use. So it really doesn't matter what did or did not apply. What matters is that it was an illegal use, and at the time of the extensions, it was still an illegal use. And so I'm just asking a question. If the answer is no, the answer is no. Did anybody in the town request an amended order?
No.
Is that something that could be done?
At this point, no. The issue we have is, the way the special magistrate's set up, they're an independent hearing officer. The city is a petitioner before that magistrate, and there's an order that the town pursued, the town obtained, and no one appealed. And it's there, it's final. And so, that's the complexity of having a case go on for a long time. And the magistrate, as Mark said, is human nature is to work out some mechanism based on the facts that he has to try to get this thing cleaned up. It's obviously, as been said a couple times, it's not a good situation to have an ongoing business down there. It doesn't have any necessary approvals. And then you're left with the complexities of transitioning from one code to another, a new town, transitioning staff, a use dichotomy between the two, and I think and then we go through the timeline, the efforts that were taken prior to the town's ULDCs come into effect. I think the order is the result of it, and that's the order that the two parties, the town being one of them, and the respondent being the other, the traveling under.
Just to clarify, I think I heard you said the town could not at any time go ask for modification
you go down,
during an extension hearing?
It would be the same thing as having a respondent come in after the fact and after everything asking to amend the order themselves. The order needs to be taken care of by the magistrate. If you go back now, you're asking them to change like a final determination, so to speak.
Okay.
The statute provides remedies and whatnot too, which would fall outside of.
Could you briefly, because you've done it here, but just to clarify in my mind, what arguments or facts would you give to support a finding that the town ought to look to the county's ULDCs for, that this application should be reviewed under the county's ULDCs? You've done it, but just if you could summarize.
Yeah, well, the principal argument is the fact that the county's ULDC was in effect at the time of the violation and the time of the magistrate's order. And the magistrate ordered that a remedy be implemented consistent with specific sections of the county's ULDC.
And the question, Mike, I have a question for you. Do you think the town would be arbitrary or capricious if the council reviewed this application under the county's ULDC?
No, it would not be arbitrary. If you had a range of analysis and options, and this is one of those, falls within the reasonable range of how to move forward in this, which, from what I understand, is unique at this point.
My next question is, what arguments or facts would you give to the town council if they wanted to review this under the town's ULDCs? What would you give to support that determination?
Well, the magistrate's order was very specific to two sections of the county's code. And that being the case, he didn't necessarily address other land development regulations that could be applicable. So the way that I originally reviewed it and did the staff report in November was that I took just those portions of the county's code that were specifically referenced by the magistrate. The balance of my review, I performed using the town's land development standards. So, that was the initial interpretation that I took, based on what happened here in November, and my going back and doing a more detailed review of the magistrate's orders and ULDCs. I changed my approach to go solely with the county's regulations. But I also, in the conditions of approval, I did add some conditions of approval that were consistent with the town's code. I think we have the flexibility to do that.
Okay. And I'm going to ask you the same question, Mike. Would the town be arbitrary and capricious if the town council used the town's ULDCs?
I don't believe they would be, but again, it's that range. I think, there's reasonableness associated with applying and interpreting codes. And the planner has analyzed this carefully and I guess thought this the most appropriate course of action given the circumstances.
Jim, in your opinion, what makes this situation unique and not applicable to any other? That is, where we're using the county's ULDCs instead of.
Yeah, well, primarily, number one, it was a result of a code enforcement action that sort of fixed, in my mind, the time frame or the time at which we should be using land development regulations. The notice of violation and the magistrate's order were issued in 2008. The town did not have its own land development regulations then. The county did. I'm not aware, and I'm pretty certain that I can state that there's no other circumstance currently in the town that would meet the exact set of conditions that we're taking this one through.
Mark, are you aware of anything Jim has said he's not aware of anything. I'm presuming you're not either, but just in case you are.
Sure.
Okay. Mike, based on what you just heard, is that sufficient for you to opine that this is unique enough that we're not setting a precedent?
I always preface the answer to the precedent question as each case has to stand on its own, 4 legs or whatever. But that being said, in reviewing in this matter, which I don't review all zoning matters and whatnot, but it is unique in that it's a case that transcends that change from county to town, with a component that the enforcement action kind of dictates which course is more appropriate. I don't know of any other case that I've been made aware of where the enforcement has started before the ULDC and it's bridged over into the new one and involved a use that changed so significantly between our code and the previous code.
Well, you gotta remember here, Vern, that although it was okay under the county code, it took Board of County Commission approval to get this done.
It actually, as a principal use, it took BCC approval. As an accessory use, it took administrative approval. Just to clarify.
Yeah.
And then I have one other question. What's the amount of fines roughly that are outstanding?
I don't have that number in front of me, but I recollect it's close to $100,000.
And the rest of my questions really pertain more towards very specific details on the site plan, kind of along the line of a couple of questions you asked. So if I can continue, or if there are other more generic questions.
Let's see if there's more generic questions until we get into the weeds on there. Trish, do you have
Okay,
anything
yeah.
specific?
I do, and I'm going back and I'm sorry, but is the Exhibit D that you have in this timeline, which is really great, by the way, the actual violation that you received?
I believe so.
Okay. The way that I'm reading this is the description of the violation is the landscape service permitted in this zoned area is only permitted in conjunction with the retail or wholesale nursery. So the violation is saying that the landscape service, you're in violation, you can't do it unless you do the following. It's not telling you that you have to do the following, it's not suggesting that you apply to do the following. So again, I go back to what the special magistrate's finding was, and that was to come into compliance with the county code at that time for the use that you were given a violation of, which if this is the violation, it's for the landscape service. It has nothing to do with a wholesale nursery.
That's true.
So again, I would say that the remedy that you're requesting from us is not consistent with what the order that the magistrate gave, which was to come into compliance, which the only way that you could do that would be through a Class A special use permit, which based on the standards that you've given us here, and maybe I'm misinterpreting this, outdoor storage of debris, however you interpret the word debris is prohibited. And that's the catch, that's the thing that keeps, I mean, this whole application, and like Veronica said, I do have some issues with the site plan and some of the conditions of approval, but I cannot get past that point to even consider the application.
Yeah, for storage.
And when we talked about this, was it in October that this first came? I talked about it then, where if you had a legal non-conforming use and we were just trying to change it over to be current with our code today, I get that. But this was never legal non-conforming, this business was never legal. I do believe there was a time frame when it could become legal. I mean, the moratorium on the land use applications, are you telling me that if they came in to apply for a land use at that, or for a licensing at that time, which would have been, what would you have applied for at that time?
Site plan approval.
Okay, site plan approval. It's just not consistent. If we knew they were out there, we knew there was a moratorium, why are we giving them a violation and starting fines if we know for a fact that they can't come in and remedy? It makes no sense to me. So I really do think that if we are to move forward with this application and we are going to look at it, we can't flip-flop back and forth between the county and us. If they want to come to us and remedy the situation and actually do a wholesale nursery as a primary use, and in my mind, that doesn't mean because you have 0.01 acreage more than your accessory use. Your primary use is what you're generating your money from for your business. There's no definition. There's no clear definition. It doesn't, I mean, just like you say there's no definition of debris, it's, you know, how your definition is the same, is different from someone else's. I really do think that, and I don't have an issue if you're coming in and you're telling us you're a wholesale nursery with a secondary or accessory use as a landscape maintenance company. But I don't, this back thing that we're doing, and I think ultimately the goal of the magistrate is just to get you legal. I really do. But if the magistrate is saying you've got to use the county code, and the violation is saying you're in violation because you're running this landscaping nursery service, and you can't do that here, that's the use that I believe the special magistrate's intention is to use the county standards for.
Can I, because I'm a little bit unclear as to what you're saying. The violation says that we can't have a landscape service company without any ancillary, without a primary nursery use, right?
Correct.
Okay, so under the code, you need administrative approval for that. Now, we were cited for that, but keep in mind that under the code at that time, we were allowed to have a principal landscape service use, and that required BCC approval. Okay, so
Right.
so putting that aside, we were cited for this, so what we did was, okay, we can't have our landscape company on its own, so we're gonna add the nursery component.
No, that's not what it says. It says, this violation was issued by the town of Loxahatchee Groves. So the town of Loxahatchee Groves is telling you, correct? I mean, it's the town that's citing.
Town side.
Enforcing the county code.
But the county code allows you to have a landscape service. Correct? Through
BCC
a public hearing
Right.
process, correct?
Right. See, I don't think that when they issued this violation, I think that they misinterpreted the code and thought that it was only, a landscape service company was only permitted as an accessory use. That's what I believe. And so in order to come into compliance with this violation, we have to add a nursery component, and that's what this site plan represents.
Can I shed a little bit of light in? I've been from the very beginning when this was first issued.
State your name for the record, please.
Harold Worthington, I'm with Magic Properties. When we first obtained this, and this is going through a little bit of timeline, so, but I think it'll clear up some of these questions. When we first got this, we appeared before the magistrate, and we were working closely with Calvin Giordano and Associates, which we worked with several times on other jobs, other cities, and we were working with a man named Will Davinsky, and then later Kerry Tulos. They were both your code enforcement for the town of Loxahatchee. When we went through the violation process, we were given I believe it was 60 or 90 days to come into compliance. We actually did that, and even in my discussions with Matt Littman, the town clerk at the time, they were even waiving the fees and all for that. Exhibit G here shows that we actually had the nursery part installed. It's a Google Earth. We didn't take any pictures or anything of that. But we were operating as the wholesale nursery with the landscape service for a period of more than 2 years. We never had any other problems from the town during the whole moratorium process, no other violations. Now, once everything was then put back, the moratorium was ended, your stuff was adopted, then the new code enforcement, Bev 2, she came in last August. After the previous winter, there had been a big freeze, and she said, oh, there's no landscape service here because there were no I's dotted, no T's crossed in this end-all be-all file that she was looking through that she had received from Calvin Giordano and Associates. So she was going back through old files, just clearing them up. Then we got an order to appear, and it said, oh, by the way, you got this $100,000 or so fine up. Went back before the magistrate and said, hey, this is all of the history. Went through, as Mark said, all of this same testimony, what we had done, why we did it, that kind of thing. During the winter, 2010, that was the big freeze winter, and we had a lot of tropical plants out. They died. Our branch manager that was running this branch had died the previous summer. The new guy didn't understand how important the nursery part of it was, and so when they died, he hadn't replanted the stuff. So that area was, if the nursery had been there, when Bev went there, she would have just said, oh, yeah, they're in compliance, there's a nursery portion here, and we wouldn't be sitting here today. But there are a lot of things that happened that caused the magistrate, when we went back, to say, oh, well, there's an order here, All you have to do is go back and comply with this order. When we did that, we said, well, what do we need to do? They said, well, the only thing you hadn't done, if everything you said is correct, is get a business license. So we take the business license, turn it into Mark. Okay? This is at the point with this magistrate that we hired an attorney
So what's your business license request for
for
at that time?
for a wholesale nursery and landscape business that we turned into Mark a year and a half
So just-
ago, which
just-
started this process.
For obvious, I mean, this is just like staring me in the face. Then if you applied for a license to do it a year and a half ago, why aren't you doing it? Why don't you have your wholesale?
Why don't we have a license?
No, that, you don't get to ask me a question and a question. I ask you a question, I would respectfully request an answer.
Because we had to go through the site plan approval process to do that, and that's when we filed the site plan application.
So when
And
you,
prior to
when
that,
you
it was-
applied for the business license,
That's
Through the
correct.
town.
I can't give them a business tax receipt if they don't have the appropriate approval for the site.
And we
Okay.
couldn't do that earlier because of the moratorium was in place from
okay, with that
2007
being
to
said, to
2011.
be a little, catty, then why continue to run your legal business without a license and not, I mean, just for good faith purposes, why not just run your business that's required, that you knew was required, I don't know, whichever one of these dates, back in 2008 or 9 or 10 or 11 or 12, why not have your wholesale?
Why not run the nursery? even
Yeah,
though we don't have
I mean, I
rules?
went on your website, I did a little investigating, I went on your website, and it's a great website, whoever does the website design for Valley Crest is very good. And it has all these little buttons and tabs and information, and if you want to find out where the closest landscape maintenance location is, you type in your zip code and they all come up, and there's the one on Okeechobee Boulevard. And there is nothing on the website that points to that address as a wholesale nursery. As a matter of fact, the only nursery that comes up is the one that's out in California, the Tree Farm. So, I mean, if anybody wanted to know if there was a wholesale nursery here as a wholesaler to go buy some landscaping, you have nothing. No advertising, no signs, no nothing that
Right,
says.
the wholesale nursery component is going to serve the landscape service business, okay? And I'm not, quite frankly, we would prefer to have just
I know.
a landscape service business, but we understand the issues and what we face, and so we're going to institute a nursery component as the principal use on the property.
So then it's not really going to be a wholesale nursery, it's going to be just a nursery that supplies vegetation for your business.
It's going to be a wholesale nursery, yes.
So you're gonna purchase plants from yourself. By definition, wholesale nursery, which I think is in this code or one or the other, is for the sale of plant material that will then be resold as retail. So if you're a wholesale nursery, you're not going to be selling your products to wholesalers. You're just gonna be using it for your own use.
We can do both. We
I'm
have several.
I'm
we have
asking, I'm
several
not
nurseries.
telling you what to do.
Right, we have
I'm
several nurseries.
asking what it is you're doing on
We
the
have,
site.
we have several nurseries. So,
Remember Joyce, if I could, I would say though that, one thing I would tell you, because we were worried about the same thing. Although we want to find a remedy, we want to cure the issue, when our code enforcement folks and myself, when we met with Harold and David, that was one of the first things that I insisted. I said, this can't be a dodge or a way around the code. If this is the remedy you're pursuing, primarily, principally, the use has to be a wholesale nursery, and then your landscape services have to be accessory. So that's always been the town's position in the back of our mind. It's not like, we're trying to, let them exercise a dodge to get a cure, if you will.
I hear you.
and we have always been forthcoming on the other side to say we had rather be just a landscape service. But if that is the requirement we satisfy, we have several nurseries. Most of them are much larger than our 5-acre site that we have here. We have 20 acres down in Homestead. We just sold a 65-acre one in Orlando. So we have several ones that support our business around. If we need to put plants on here, we're perfectly capable of running a nursery.
Yeah, we'll comply with whatever is required, and I mean, there's an implication that we're, and I know these are great questions, but there's an implication that we've acted in bad faith, we've avoided permits, we've sat on our hands, and it's just not the case. And we'll run through the timeline, but we want to be a good business, we want to be a good neighbor. We haven't had any complaints, but if you look at the timeline, we've had limitations as well as to what we can do. I agree with you that when we bought the property, we did not get a business license from the county. It wasn't in bad faith. They didn't know that they needed a license. As soon as we were put on notice that we needed a license, we would have gone and gotten the site plan approval, but the moratorium was in place. So we couldn't do that for a number of years. But during that time, we worked with staff, we developed a site plan with the nursery component, and that's why we're here today. But any implication that this company is trying to skirt laws or act in bad faith is not true.
Just one question. The use code for this, for tax purposes, for property tax purposes, is single-family home. If you had a nursery owner at once upon a time, why didn't you apply for an agricultural exemption?
I don't know.
And that would have at least been something in the paper trail that would have shown, you know, that you were an agricultural entity. So, all right. Chris,
Like Veronica, I have some things pertaining to the site plan and.
Go down to Mr. Crawford. Any question?
Yeah. What's your thought on how this would be judged? Like, once they put a nursery in, who's to look at it and say, all right, this is not a Dodge, it's a nursery? Has there been any discussion?
Well, obviously, we would rely, let me paraphrase your question. You're saying, in other words, you know, they get the nursery, but then they're not really doing the nursery, but they're doing the land.
They're parking their trailers on the nursery, you know, who judges that? I'm just curious, like, we talk about, you know, this isn't gonna be a Dodge, you know, in good faith, it's not.
Okay, I think there's a couple of ways. Number one, I'm sure if we have anybody that comes in and says, hey, take a look at this, and they file a complaint, that's the normal way we do code enforcement in the town. However, because this has been the subject of a code enforcement case, I would think that the town would still be within its rights and not violating its own policies and monitor and make sure that it's complying with the, you know, with the approvals and the orders and everything else. And if we, it would probably be a judgment call, but I think if we were to view the site and it appeared that really the nursery was a facade and it really was lawn services, I think we would, you know, we would talk to them and try to resolve it. And, you know, so far, every indication they've given me, they're trying to comply. They're not trying to, you know, dodge anything so far. I mean, that's just my opinion. I mean, you know, they've spent a lot of money in cost recovery and things like that. And they're certainly attempting to, from my standpoint, you know, try to do what they're supposed to do. And if I felt that they weren't, I mean, you know, I've told David many times, and he can tell you that I've kind of said, if you complain with me, you know, we're going to take a whole different approach on this. So.
One other thing is, when it gets the final approval from the council, it's going to be in the form of a resolution. It's going to have basically, you know, the standards are all going to be put into a resolution, kind of like an order. And it's going to rely on the conditions that come through this board and the council. They're going to provide a checklist, because, you know, you haven't gone through it yet, but there's conditions of approval. You know, staff, you all may add some or change some, council may do the same, and it's going to provide some, my sense is, necessary safeguards to understand that this will continue to be operating consistent with the approval. And it's going to permit staff to review that as needed, and they can always, Mark says, they contact and work it out. If it's obvious, egregious, or whatever, they can just go straight to the magistrate for violating a site plan.
Yeah, there's some pretty detailed compliance conditions in the conditions, and also some pretty severe penalties for not complying with the conditions. So I think that's covered. And keep in mind that's a very visible site. Sure. It will be pretty easy to monitor what's going on.
motion, yield my time until we get to the site plan specific.
Okay.
Just one quick clarification, and I think Board Member Joyce raised a really good point. I just want clarification. Are you asserting that the reason that you're not in compliance with what you knew you were not in compliance with, is the reason you're asserting that it's because you were waiting on approval on the site plan, or is it because, I just want clarification, and I don't want to put words in your mouth. I think her point is a good and valid point, in that still, even though for a couple of years that you haven't been in compliance, and you're still not in compliance, what is the reason not being in compliance?
Well, the reason is that, as we stated, is that you need a site plan to establish a use on a property. And so, once we were put on notice in 2008, when the violation was issued, there was a moratorium on site plan applications. So that moratorium was extended all the way till January 2011. Okay, and once that moratorium ended, we were communicating with staff, and we submitted the site plan thereafter, and have been in that process for some time. But it was the moratorium that prevented us from getting site plan approval.
And would you think you would be in a better position have you at least started work on the nursery aspect of it?
But you can't establish and start a use without getting approval from the town.
And also, I just have, there's wide latitude in what you all discussed, but you're talking about a site plan as opposed to your enforcement type thing. I mean, the fact that it's out there may let, and it's ongoing, you may factor that into, whether you have to make some credibility or something like that, but it's not a condition of the site plan application itself. The technical aspects of the site plan. I just want to get us back to the fact that regarding a site plan application, and whatever motivations or whatever actions are ongoing out there, I mean, they're being addressed in a different form. They chose to take a business risk and violate the code and continue while they're going through a process. People do it all the time, and at the end of the day, it may be reflected in the ultimate fine that they face or sanctions. So, it's not uncommon, unfortunately, that occur. But we're here on a site plan, so I just want to keep us on the site plan for the record.
And just to clarify too, I mean, we tried to go in through the code compliance officer at the time and have him sign off on a site plan, and that's what's included in your packet in Exhibit G, was a draft site plan. Unfortunately, Kelvin Giordano, we've been trying to reach them and see if they have any records on this, and they can't find the files. But this was what we tried to negotiate with the code compliance officer, and we did institute a portion of it as shown on the aerial. That aerial was taken, I believe, in 2009. So we tried the best we could to come into compliance with the tools that we have.
And my last question is that, from what I heard today, is that we are able to use both the county code as well as the town code. Is that correct?
Well, and this is unique, okay? If you had an application come in that had no history and dating back to 08, 09, if it's a new application, you're not applying the county code. But what's happened here is a combination. You have an application that bridged that transition. It was open that time. There were actions that were taken, planning actions taken by the town that could be seen as impeding their ability to complete tasks. You had a special magistrate who took a view of the case, and his entire case and review was under the county code, because that's what was brought to him initially. So under those circumstances, that's why we're dealing with the county code. But if an application were to come in and say, they can't cherry pick what they like best, they couldn't say, well, the code allows it, the county code allows it, so I'm not going to do the town code. That is not an option. But in this particular case, the circumstances of it, like I said, we've been going down this path, led by the magistrate process and whatnot, for quite some time. I keep saying unique. I believe this is, from what I know, very unique circumstance.
And my last question would be, can you articulate the difference between town and the county code when it comes to this particular plan?
That's the planner's job.
Yeah, what's the question?
Articulate the difference between the town code and
Yeah.
town code.
Yeah, I have a section in here where there's a table that I have in one of the attachments.
It's E7.
D7 has the basic land development regulations. And if you look at that table, they're really fairly similar, and with the exception of the rear setback, the counties in many instances are more restrictive than the towns.
The county's more restricted than the town?
In some instances.
Yes, Ryan?
I have a couple follow-up questions, generic, based on some of the statements that were made.
Okay.
You made a statement that you tried to contact Calvin Giordano, but they couldn't find the paperwork. Are you suggesting that they signed off on a site plan, but they can't find that approval?
That's what I observed, yes.
They actually signed off on a site plan, and I'm assuming you would have gotten a copy of it.
That is the site. That was in their file, the one in the.
You submitted an application
No,
for a site plan?
unfortunately, it wasn't. Again, this was, we were trying to do this through the code compliance officer. It wasn't a formal application because we couldn't do that because of the moratorium. So I think we tried to, well, I wasn't around, but Harold tried to work with the code compliance officer because at that time it was, and it is a code method. And so we were working with them and trying to get their sign off on the site plan so we can resolve this.
But Calvin Giordano could not approve anything that was in violation of the code or was prohibited by moratorium, whether it's a court case or not. Am I correct in that, or?
Yeah, they would not have given like a formal approval of the site plan, that's correct.
Right, but, and this was, but they did this before the town code got adopted. And I agree with you, that the code compliance officer can't approve a site plan. And what I'm suggesting is that it showed our good faith in trying to resolve this in some way while the moratorium was in place.
And honestly, we thought that it was resolved. When we signed it off in the field, had the nursery up and running, inspected it with Calvin Giordano, and that's the last we heard of it until
That was
2 years later.
And that was 2009, right? You didn't hear anything
It
until
was-
2011.
Yeah, it was December 2008, and we didn't hear anything until 2011. That was the first thing we heard of it, so, you know.
And you said this, I want to make sure I understood you. You said this Google Earth picture was a picture of you using it as a principal use as a nursery?
Yes.
I only see a very small plot
Yes.
being used as a nursery. How in your mind does that equate
Is
to principal use?
a tree farm a nursery?
Not as a
No, no.
principal use.
Yes, principal use, I'm asking about.
Yes.
Yeah, it
A
probably did.
square of probably 1/50th of the total land area, in your mind, is, you consider that to be a principal, do you consider that to be a principal use under the county's definition?
The only
With all due respect, he wasn't the one there at the time. According to what we had with Calvin Giordano, who represented the town, it was.
Right, but they're not here, so
Right,
unfortunately.
yeah,
I'm with you, but I'm just saying where we were.
I think at that time, the code wasn't analyzed to the extent it was now. I wasn't involved, and I think that they were just trying to do something to demonstrate good faith.
And just compliance, doesn't necessarily, I know we're not supposed to talk about this, but actually, we're being asked to review this under the county's ULEC, and the county's ULEC is part of the code case, so I think it's natural that we would ask questions about the code case. Compliance could have been, you could have come into compliance by relocating the illegal business. That was always your option, and then go through the necessary procedures. I just want to establish that compliance, there's not, the only solution to compliance wasn't getting approvals.
You're
But
saying
relocating
terminating
the
the
business.
business, on the property?
No, you're not, on the property.
Right, no, I understand.
Yeah, relocating the business,
No, sure.
that's another option. All right, and then, that's all I had, questions, statements of right, and they have one follow.
Joyce?
Just for clarification, the county code that we're using to establish the site plan based on the violation is for Article 4, Chapter B, Section 89, which is nursery wholesale. So we are looking at, these are the use requirements.
The Article 4 is the use matrix.
Well, it talks about limitation on sales, approval process, hours of operation, parking, buffering, and goes on and on about, these are the things, if you have this use, these are the things that you must do in conjunction with it. Correct?
Yeah.
Okay.
Yeah, no,
So-
okay, you're talking about that attachment.
On Exhibit B1, where the first section talks about the landscape service, which this is not their primary use.
Right.
So we're gonna go to the second use, which is nursery wholesale.
Mhm.
Okay.
You're reading from page B2
I'm on Exhibit B1, which is
B9.
B9.
or B9? Okay.
So we go down the list and it, you know, these are all the things which they're required to do. And then we get to the section on page B12 where it talks about outdoor storage. For accessory and temporary uses, which I'm not, you know, really clear on how we jump over there, but my question is this to you, Jim, because it talks about outdoor bulk storage as it pertains to the wholesale nursery. Now we're moving into our accessory use, which if we go back, the accessory use is a landscape service, okay?
Mhm.
And it talks about accessory and temporary uses, and then it goes to outdoor storage, which is on page B12, item number 3. And it just addresses the terms and conditions for outdoor storage in all non-residential districts. There's nothing in here that dictates what the outdoor storage would be in a residential district, which is what this is. So if we're using the county standards to get them where they need to go, what are the standards for outdoor storage in a residential neighborhood?
Palm Beach County Fire.
Or agricultural residential, what are the storage? Because, I mean, it talks about AR throughout here and some compatibility issues where things are applicable, things are not applicable. But as far as outdoor storage goes, as it's related to accessory uses, I don't know, because I'm thinking, you know, you've got this debris pile out there, how do we allow them to do that as part of the site plan? How do we allow the site plan to move forward with that if we're directed by the special magistrate to bring them into compliance with the county code if there's nothing in the code in this exhibit that addresses that?
Well, the principal criterion that I used was the one on B11. It says that in residential districts, outdoor storage has to be set back within 50 feet of property.
Well, but that's outdoor bulk storage as it pertains to the nursery. Because you're going, is how I'm going, if I go from page 10 to 11.
Yeah.
This is all in conjunction with the nursery wholesale. That has nothing to do with the,
Yeah, so
secondary use.
that's all I had. I mean, that's all I could find.
well, does the county code talk about outdoor storage in agricultural districts?
Not that I could find.
So, in your history and in your experience, when something is not addressed in the code, is it permitted? If the code is silent on something,
I'm not sure I can give a blanket yes or no on that. Some instances I think are open for interpretation, and some I would say probably not. I would say in this instance, since we have a principal use of wholesale nursery, and this is an accessory use to a wholesale nursery. There's nothing wrong with using the criteria for outdoor storage for wholesale nurseries.
Well, except for it doesn't address the landscape debris. And I think in this instance particularly, it's very important because it does have an impact on the neighboring properties.
Yes, well, we have a whole series of conditions in the recommended conditions that apply to that to try to address those issues.
My experience for the record, and Veronica is, we're kind of in the same line of business. If it's not, if the code is silent, it's usually prohibited. But
Let's move on to the site plan, and then we'll get to, after the site plan, we'll get into the conditional uses and maybe some of those concerns that you have. Is that okay with any objection to that? All right, Keith, you want to start with site plan questions?
Site plan questions?
Do you want us to walk through the site plan? I mean,
That would probably be, that'd be a good place to start.
okay. Harold's going to walk you through the operations on the site plan. Actually, before he starts, in response to the board's comments from the prior meeting, we've worked with staff, and you'll see that the yard waste pile we reduced, it was initially 200 by 100 feet. We reduced it to 100 by 100. And there's some additional restrictions that we've incorporated, including buffering, dumpster, and the fuel pumps.
Yeah, we have the main entrance here, and then, like you said, it's pretty self-explanatory for the nursery areas and nursery storage and yard waste, and the parking of our vehicles. We have an existing building on site for maintenance of our 2-cycle equipment, an area for our employee parking, and our office existing for our nursery and landscape employees. I don't know how much further you want to go into it, but
All this is existing. There'll be no structures built.
Okay. That's pretty straightforward. Start with Keith.
What's your intent to comply with the setback condition of the building encroaching the setback?
This building here, when we changed the approach and moved from the town's code to the county code, the setbacks are slightly different, and we now comply with the setback under the county code.
Under the town's code, the setback for any structure is 50 feet. Under the county's code, our rear setback is 100 feet for principal structures and 25 feet for accessory buildings. This is an accessory building, so it now applies.
Your fuel depot, Jim, you mentioned there was an inspection by fire marshal, and it did not indicate any exception with the existing fuel systems.
Well, when we had our initial meeting, I guess there was some discussion about whether or not the fuel tank required any kind of permit or monitoring. And due to the size of the tank, it does not require a permit. That's my understanding. I think that's what the fire district told us at that initial meeting. But the tank right now is visible from the road, and it's just sitting out there. One of the conditions to make it come into compliance with the regulations is that it be screened.
All right, does the existing fuel system have any spillage containment device to it?
The tanks themselves are contained. They're double walled.
They're double vaulted. The only other issue or concern I have is the debris pile. It contains materials brought from who knows where. can contain exotic species, it can contain insects and vermin that is not acceptable for the area, and I do not wish to see it on the property. So those are my concerns I pass to my colleagues.
I did want to mention that with respect to the waste pile, not only did we reduce it in size, but we're going to grind it every 90 days, so 4 times a year. And we've calculated that so that in doing it 4 times a year, it will not exceed the size, and then there's enough property to spread the mulch for the chips.
When was the last time you,
Over the nursery.
when was the last date that you did a grinding?
I'm not sure, I'm not on that site regularly, but the existing pile is set to be ground as well.
But keep in mind, this proposal is going forward. I'm not saying that we've complied with what I'm just
Right,
proposing.
I'm just,
Okay.
from my knowledge. And it's my understanding that the material is to be used on site once it's ground. What will it be used for?
The nursery and for fill and for screening.
Any resale?
No.
Again,
And let me say too, one of the other things that has happened, because we are expanding our business in the southeast Florida, that branch is actually recently split, and we're down to half the size we were just 2 months ago on that site. Just, I don't know if that helps you guys understand that any or not.
you're saying that your scope of work has been decreased by 50%?
Yes,
Activity-
we've actually split.
activity-
That branch split into 2 branches, and another one has relocated. We've opened up another site elsewhere, so that specific site is just happening in the Wellington-Loxahatchee area. So we have, as you probably know, we have Homestead, Medley, Kendall, Delray, Fort Pierce, so on and so forth. And so as we have them, because of fuel costs and other things, you know, money talks. So when we have another area that we can get to, our branch is split. So that branch is actually much smaller than it has been over the last 2-3 years. You know, and that's just happened in the last 2 months, just for your educational.
Thank you. That's all I have. Keith?
Ron?
So I guess I'm just gonna focus on the debris pile. Once you mulch it, is it to be done in a decomposition?
Composting?
Composting.
Yes.
And so, and what's your process for composting? Do you actually do it in a manner where you promote like the bacteria stuff to eat it up, and you turn it every so often?
Yes, and we put together a management plan for that. There is moisture inherent in it, which you need to get the chemical reactions for the composting. But basically, it's decaying, and with the grinding, we probably get about 8-to-1 settlement, and then once we grind, we're between 30 and 50-to-1 of condensing that area. And then over time, as we use it, it continues to go down another 100-to-1 on top of that. So you're really, it's going away. All of the organic matter and everything is getting eaten.
So, and visually, how does this work? I imagine it could be 15 feet tall, pyramid. Is there a screen around it? What would the screen be?
That's what we're talking about, is under this, we will be doing a screen so that it won't be visible from the road.
Yeah, that's one of the conditions of approval, is that it has to be screened from the site.
Is it a mechanical screen or a landscaping screen? Have you gotten that far?
Well, it either has to be some sort of an opaque fence or a landscape screen.
And, well, is there an idea for requirement to say, we have a hurricane, you know, what keeps it? I don't know if it's a big deal, but, you know, because I guess pine needles blow around too, but this thing is a long way, so is there a requirement that it would stand a certain amount of?
We don't have anything in there at
I
this
just
point.
was wondering.
I mean, we can
And I don't
We can
know,
always
it's
talk about
100 feet by
additional
100 feet, And my other, going back to this, do you have an idea how this would look? Do you do you see the landscape business as being kind of hidden and the nursery visually accessible from Okeechobee, or is it all just kind of open as far as Okeechobee?
I know you guys have probably ridden by this.
Yeah,
It's pretty well screened from the road.
Right.
I mean, other than us having to have an opening,
Well, and that's
you
my
don't
question.
see much of us
Do you
anyway.
want to hide the nursery? Are you going to try and make it more visible, or?
Well, the nursery component is gonna, part of it at least, is gonna be along with Okeechobee, so we'll
Right.
further make, make that screen even denser.
Right, the nursery, but you're not going to try, because like when you go by, what is it, was this Quintessentials Nursery, you can see in there.
Joey,
We're not trying to attract people to the nursery. It's a
Okay, so
wholesale
you're
nursery.
not, even as a wholesaler, you're not trying to attract.
No. Wholesale, like Ms. Joyce said, it's gonna be
Sure.
by either other nursery owners or.
But MSA
online.
is wholesale only, and they're highly visible. It's, it's nice.
Some people like to attract attention, some people don't.
Sure, and I was just curious on how you guys are looking at that. All right.
We would be perfectly happy if you never looked that way if you were riding by.
Especially
now the big spotlight coming out of the church across the street. is
See,
very-
that
is very-
takes away from
It's
it,
very
right?
troubling. But anyway. Board Member Joyce?
Okay. Starting on page C-1, attachment C. I would request of staff or make a recommendation that instead of, if this were to get approved, instead of creating a legal nonconformity right off the bat, with the setback of the building being 47.2 and the town requires 50, why not just ask for a variance, bring the building into compliance, and be done with it? That would be, and you don't have to comment, I'm just gonna throw it all out there. The second thing is the parking and loading requirements. There are specific parking requirements as it pertains to wholesale nurseries and the buildings that are located on them. And it's 24 parking spaces, you're proposing 24 parking spaces, and I drove past the site 2 times a day and made a special trip and pulled over to clearly view the trash pile or the debris pile that's there. It is not well hidden from the right of way. And there, in my mind, as part of this site plan approval, needs to be designated parking spaces, including handicap parking spaces. Again, if we are trying to bring them into compliance by not requiring what the requirements in the code state, which are,
I don't think wholesale means
well, it's size of parking spaces. I would, does it, Jim? Because if it doesn't, then that's a moot point.
Yeah, it's not open to the general public.
No, we're asking for code.
Yeah, off the top of my head, I'm not sure about that.
Well, I'd like, if you could, to look into that, because I know that there's ADA requirements. We don't want to be in violation of the state code if handicap parking is required, because I know even if you require 1 space in most cities by code, it'll be a handicap parking space.
Just so we don't go too far askew on that, what you could do, if you're moving forward with it this evening, is put as a condition that it be confirmed before it gets to town council and address and be consistent if there needs to be a change. Since you don't have the answer tonight, whether it's required.
The other item is the loading space requirement. I'm not sure where that is. If you could point that out to me on the site plan.
It's right in front of the existing maintenance building. What they really have here is, they don't have a parking lot, and they don't have a designated loading area. They have a parking field, if you will. It's a big open area where they park, and handling duty and loading.
Well, currently they park all over the site. That's what they currently do. I realize this is the proposed site plan, so what I'm suggesting is if they're going to designate an area for the nursery because that's the primary use, and then create a new parking location, then we really need to comply with the requirement of having a 15-foot wide by 55-foot long with a 15-foot vertical clearance loading space. These are just what I'm suggesting. I did hear you mention earlier that there was a dumpster on site, but according to this, there isn't. No dumpster on site.
No, there's not. That was one of the requirements that we told them they had to meet.
So there, because it says here dumpster with recycling.
Yeah.
So is there a dumpster or not a dumpster?
Currently, no, but
No.
there's one proposed on the site plan.
Yeah. That's,
Okay, because it's proposed, it says no. Does that just mean there isn't one, but that they are gonna put one, so?
they are going to put.
Okay, all right, fair enough. Here's the one that really gets me. The landscape plan. You're asking for a waiver of the landscape plan, and you're telling us you're a wholesale nursery. I would think that you'd have a ton of landscaping available and provide us with a landscape plan, because like I said, I drove by here today, there is a clear shot. You can, without stopping, see the pile of debris, you can see the vehicles, there's a huge open spot in this section where you can see straight through the back of the property. So the buffer that's existing along here in whatever, this was 2009 or 8 or whatever this photograph is not what's there today. So I would, you know, I was gonna take pictures, but I really wanted to get home so I could get here on time. I think there needs to be a landscape buffer. I think there needs to be a landscape plan. I would not support a waiver of that as part of the landscape, as part of the site plan approval. Moving on to signage, I didn't see one in the site plan.
None proposed.
So how are people gonna know you have a wholesale nursery there? I would think that if you have a business, you'd want a sign. These are just my comments.
Yeah.
And then back to the miscellaneous provisions, the screening, existing perimeter landscaping, I do not believe is consistent with the code. I don't think it's enough. I think we actually need a landscape plan. And that's really it for me as far as the site plan goes.
We do have a requirement in here that they must file the vegetative pile, be screened from Okeechobee, so that issue should go away.
Yeah, but we need to see what that is, Jim. I mean, we want to move forward so everybody is happy, and that this illegal use can become legal.
So you want to see like an elevation?
No, I want to see a landscape plan. I think if the code requires there be a landscape plan, I would not support a waiver of a landscape plan. They've got the room to do it. They're a wholesale nursery, so there shouldn't be a cost associated with that. I mean, I know that you have landscape architects and designers in your company, so not to provide us with a landscape and asking for a waiver of that standard, I think I would not support.
Jim, just for clarification, what the reason for the waiver of the landscape plan is because there's nothing in the code that requires anything above what we already have here. So what she's asking is just for her to show us what it's gonna look like, is what I'm hearing is what you would like.
I'm asking for additional landscaping. If you're asking for a waiver of something, that means the code is saying you have to do this, and you're saying no. If it's there already, then you're not asking for a waiver, you're in compliance.
Is there an explanation of
That's
that?
basically what we're
Yeah,
saying.
yeah, I think what she's asking for is some sort of diagram that.
Well, what does waiver mean? I think that's the first question.
I understand.
The way you understand
what
it is
waiver
there's a
means.
requirement, say you have to have 3 trees.
Right, we've already had the minimum.
Wait, just let me ask Jim on behalf of the board. There's the staff report says waived or waiver requested or something. So just to put it in simple terms, if a code section says you need 3 trees, but it can be waived, that would mean that unless it's waived, you need 3 trees. So can you explain to the board what you mean by waived, or what
Waive
that
the
what that
requirement
is?
for for a landscape plan.
It's for the plan itself, to provide a plan. You know, we didn't have to provide elevations, we didn't have, this is all existing. So it's just the requirement to provide a plan.
And is there any circumstance or conditions on when when is a waiver appropriate or when it is not appropriate?
Yeah, there are general conditions in here that when they undertake certain activities, they're going to have to come back and get these.
Oh, no, I'm just wondering about, I'm just asking the basic question about when a waiver is permitted. Is there something, I mean, I'm not as familiar with the code, and I apologize, but that's why I'm asking you the question. But is there some criteria that's met in order to qualify for a waiver, or is a waiver, at the discretion of this board or something?
No, it's at the discretion of the town manager.
The town
Per the
manager?
code.
Okay.
Okay, with that being said, I think we need to have a landscape plan that provides additional screening from the right-of-way, because I do not think that it is sufficient. You shouldn't be able to drive by there and see what's going on.
I meant to say thank you for letting me interrupt you.
You're allowed.
I just wanted to, it looked like you might be talking past each other, that's all.
Well, I mean, it even goes on further to say screening, and it says existing perimeter landscaping. And is that consistent with the code? Yes. I don't think it's enough. You're not providing, you can see the commercial vehicles from the right of way. You can see the site in certain locations very clearly, because there is no buffer along Okeechobee Boulevard. There isn't. There's gaps.
What is the, yeah, can I ask, what is the requirement for landscape? For that use?
Well, the town's landscaping requirements are very minimal. It's essentially just a 10 or 15 foot setback with landscaping. So it's not, I don't think it'll be a major task for them to do a landscape plan or at least an inventory of what they have and show how it meets the requirements.
So is this setback 15 feet?
The setback,
Parking and everything else?
the setback to the setbacks are compliant with.
I'm sorry, what?
Setbacks are compliant.
So we can have parking right up next to it. Okeechobee.
Yeah.
Do you want me to continue, Mr. Chairman?
Yes, please.
On the site plan, so that parking right up there is allowed. Are they allowed to have a parking area that is not surfaced with impervious
That's not addressed in the plan, and I felt that
No,
because
I'm asking what the code says.
it's not addressed in the code. It doesn't say that the parking area has to be paved.
Okay, and can I ask the applicant, the existing office, where's your office for your landscape maintenance?
It's all in the existing office building that's shown here as 2,166 square feet.
Okay, and then your concrete area with the fuel pumps, that's for your landscape maintenance trucks or vehicles?
I'm sorry, which area?
The existing concrete area with the existing fuel pumps is for your landscape maintenance operations, correct?
The existing concrete area is just a paved walkway. Right, you're referring to existing storage building, the entrances?
No, I'm talking about where you have your existing fuel pumps and there's concrete around it, so I'm assuming the fuel pumps are for your
On a
existing,
pad, right, on a concrete pad.
right, for your landscape maintenance operations.
And nursery.
Really, there's nursery operations that require fuel?
Tractors, yes.
Okay. And the storage area in the back, what is that used for?
This is the barn.
Barn.
Existing storage.
We have pots, we have fertilizer, other accoutrement for nursery for plants.
Nothing for your landscape services? You don't store anything for your
Nothing.
landscape services there?
Nothing, absolutely nothing. I would
It's
assume
for
that.
It's just for both.
But we have our And we do have a small nursery existing on site for our use now. You know, we do have our plants and some small trees. It's not as big as this area, but we do maintain a nursery on site.
I would be concerned that since some of the square footage is designated for landscape maintenance, it really shouldn't be included in your principal use. That's just my comment, one of my comments. Let's see. You've heard a lot of comments about the yard waste. I want to clarify. I want to just state, in my interpretation, I don't think that yard waste is allowable under the county's ULDCs. I could be mistaken, but I don't think it's allowed. And I have a real concern with it. And it is debris because they're not selling it, they're not using it, they're not sending it anywhere else. It's waste. It's just going onto the property. And so I would classify that as the dictionary's ordinary definition of debris. So from my perspective, I have a real problem with the yard waste. Let me see what other questions. Parking, the requirement for the principal use and accessory use is 24 spaces, is that right?
Mhm.
I would like to see those 24 spaces clearly delineated and restricted so that you don't have parking all over the site. Let's see. The signs, you already asked that.
Well, the spaces are delineated on the site plan.
Okay, so if they park anywhere else than there, they're in violation of the site plan.
I suppose you can say that.
Well, yes.
Yeah, well,
They could or they are.
I mean, this is, these are essentially agricultural uses. I don't believe that we're gonna go out and see if there's a car parked somewhere other than these 24 spaces. We have enough spaces on site to accommodate the cars and the vehicles. And that's, you know, if there's a vehicle parked somewhere else, I'm
Let me ask you a question. How many vehicles are required by your principal operation, and how many vehicles are required by the landscaping service?
I don't know if we have that.
Then how many are provided in relation to both? For example,
We have the traffic study, is that?
No, it's not.
The traffic's not good.
You're asking what's the requirement for each use?
Okay, the wholesale nursery, it's on the site plan, 2 spaces, landscape services,
1 space per 4 acres is the wholesale nursery, and 1 space per 500 square feet is the landscape services.
and 2 spaces for the nursery, 4 spaces for the landscape services, and 18 spaces for the outdoor storage.
18 spaces for the outdoor storage.
That, you know,
I don't understand what that
And again, those, just to clarify, I don't mean to put words in anybody's mouth, but those are basically the employee vehicles. When you're talking about parking elsewhere, there still are landscape service vehicles that are parked elsewhere, and our nursery vehicles that are parked elsewhere on the site.
is. So in addition to these 24, you have other
Yeah,
vehicles?
these are the minimums that need to be shown per code, as that we have at least that many spaces.
Keeping
That's
in
a
mind
minimum.
this concern I have that landscape uses are not allowed in this district under our code, I would like to entertain the possibility of limiting the amount of parking that's allowed on this site. Just so you know.
But you're saying that because the town code doesn't allow landscape service businesses?
The town's ULDC does not allow landscape maintenance companies in this district.
But, no, that's correct, but the town attorney and your professional staff have indicated that we're following the county.
Yes, they have told us that, but you know, of course, that ultimately it's up to the town council to determine how they want to review this application.
I mean, correct me if I'm wrong, but is that not a legal issue as to what code applies?
Well, do you want me to, because we've circled back around again to the discussion we had before. The planner has made a determination, based on the facts and circumstances, that this is to be reviewed this way, and I don't disagree with him on that analysis. The council ultimately looks at its own code, and it's gonna wanna try, I think the point that we're trying to get at here is that notwithstanding the fact that we got this unique circumstance of reviewing it, the attempt has gotta be to make it as close to the town code as we can, given the hand that we're dealt. I think that's the dichotomy that we're all wrestling with here, the board, the applicant, and the planner, is that we are in a situation where we're applying the county code because of the circumstances, but there's an effort being made to make that as compliant as the town code as we can. So,
And I would just add, I mean, I'm a little confused because I'd like to know the rationale, because like Member Joyce indicated, which I think was a good point, obviously, you know, if we want to make sure that this is operating as a nursery, I would think you'd want a sign. And as she's indicated, well, wouldn't you want to encourage at least the amount of parking plus more if you want it to be a nursery as opposed to taking parking away? I'm not sure I understand where you're going.
Right. Then, what I'm concerned about is the parking of all the landscape maintenance vehicles.
Oh,
That's what
okay.
I'm
All
concerned
right.
about.
Okay.
So I want to make sure that we're not seeing from Okeechobee, 40 landscape maintenance vehicles and no,
Nursery parking.
exactly. So that's my concern.
Okay, I get you now.
Yeah. Let's see. Something that you've indicated in your application and the conditions, Jim, is operation of vehicles over 1 ton, not before 6 a.m. I have a real problem with that. Most of your vehicles are probably diesel, I would guess. Your over 1 ton vehicles aren't diesel?
Over 1 ton? Yeah.
Over 1 ton, yeah, right. And so normally you have to start those up. And if you're starting up, so I would question what you mean by operation of the vehicles.
Do we have over 1 ton vehicles?
Yeah.
I would have to look to see if we have any.
I think you said in your application actually that you did, but I might be mistaken. And so I would have concern about the 6 a.m. start time. I would rather see it at 7 a.m. And operation being starting up as well as. And the reason I say that is, we have people living behind there who have to listen to this. So your refuse, now I think I may have misunderstood this, and so perhaps Jimmy can clarify. Your refuse container shall have a minimum dimension of 10 feet by 10 feet. Your refuse container. I think you mean your yard, an actual refuse container is going to be 10 by 10?
The dumpster enclosure.
Dumpster is 10 by
Right,
10.
the dumpster enclosure.
And I would recommend that it be screened to the height of whatever the structure is. So if the structure is 8 feet tall, the screening has to be 8 feet tall. If it's 10 feet, fine. Or a minimum of 6 feet, whichever. Sorry. Yes. Okay. I think that's most of what I have on that. I have a bunch of recommended conditions.
And this question may have been redundant, forgive me, I'm still trying to get acclimated. Why is the rationale for using the county code as opposed to the town code again? Why not just, say, even though the request was made pre-town organization being organized?
Well, because the code violation specifically referenced 2 sections of Palm Beach County Code, which was in effect at the time of the violations. When we brought the application to the Planning and Zoning Board in November, it was their recommendation that if we have to comply with those 2 sections of the county code, we might as well be consistent and comply to the extent that we can with all of the county's regulations. Did that answer your question?
But
with that being said, what would the county regulations be for landscape buffer? Because if we're kind of flip-flopping back and forth, I would be curious to know, I wouldn't expect you to know that off the top of your head. Jim, but
Yeah, I don't.
I'm saying,
And
why wouldn't
I mean,
we
especially
use,
since we are recommending that the landscape plan be waived.
that's what you're suggesting, I'm not so sure that that's
what
what.
I'm recommending, yes.
Yeah.
And that's why I don't know the answer to it.
And the town manager waived that requirement, and under the code, he has the authority to waive it.
I just have one. Okay, so Mark, you're in the now, Mark.
Yeah, I know.
You better roll up your tail. I just have one comment on the site plan. I drive by there, a few times. The church is across the street. I'm in the church several times, a couple times a month for various meetings. I think the whole discussion about buffering and about screening can be handled, pretty simply by just increasing the height of your landscaping buffering, right along Okeechobee. So when you do glance over to the side, you see trees.
Honestly, that's.
I don't know whether you can see this from across the room, but I think, when you've got your entryway, put a semicircle set of trees there, so that when you do look at the entryway, you're looking again at a bunch of shrubs, 10 feet tall, and I think Eureka palms fit in those very, very nicely because they're easily maintained, they're very tall and very dense. And then have it big enough for your grinder to get in and out every 90 days, because I'm assuming that's going to be the biggest vehicle that would come into this site. And that would then, take care of trying to get a bunch of little screening things set out throughout the property, which I think is.
And I agree with you, something like that, instead of something right by the pile or right by the field, it makes a lot more sense.
The other thing is on the reality check side, I think there's probably at least, I know of 5 landscape maintenance companies that have vehicles that rumble up and down our dirt roads. Some of them have been here for a long time, some of them are more recent. So I think that if we're going to be putting this company through this ordeal, I think it's incumbent upon town management to go out there and find the other landscape companies. I'll point out a few of them for you, but I'm not going to go out and look for them. I take a morning walk and I go by 3 of them. So I think it's just something that, if the community is going to be holding Valley Crest to this standard, I think we need to, be even-handed with this and not single you out. I know that when Villa and Son went in, they did do the thing before the board, commissioners. It slipped through on the consent agenda, and so none of us people out here really knew about it. But that's a 40-acre site, and their landscape maintenance part of it was de minimis compared to the 40-acre of nursery. Whereas in this site, it's equal. Let's face it, it is equal. And to use the analogy that it's an accessory use, I think it is plain stretch. But there's, that's the way the law is, and if that's the way it is, then that's the way it is, and if that's the stretch, then that's the stretch.
Yeah, I think I just want to say I appreciate all the questions and comments. I mean, it's been very thoughtful. But I think to a certain extent, I know there's been a lot of questions on process and the county code and which code to apply, but the good thing is that the decision is a legal issue, it's a professional staff issue, and this staff report is substantial competent evidence and can support approval of this project.
Yeah,
And so you guys can rely upon that. And so again, I appreciate all the comments and questions, but I think that question has been answered by staff.
Yeah. We get on now, Jim, with the conditions. And what page are you on there?
D is in dog, 1.
Let's take a 5-minute break till 9 o'clock for final break and whatever. And,
Bio break.
Jim, that's an opportunity when they asked you about the landscape requirements in the county code. You could have said they were Spartans. We finished 9 and 10. We finished behind 4.
As soon as I pee, they're gonna start.
I think there might be a repeat of Matlock tonight, so I gotta get going.
Matlock, is that still on?
That's the only thing I can.
Oh, okay.
I'm not a big fan of NC.
Any of them?
Yeah, but
There's like a million of them.
a million of them.
Hey, is
Well, I know it's Hannity, I'm not missing
Reba McIntyre's now in a new series? Anybody see her old series, Reba?
Oh, I used to love that show.
It's on all the time.
Yeah, on
But she's in a
reruns.
new series now, but I can't find it. Does anybody know what the name of it is?
What was it?
Reba McIntyre's in a new series.
It's probably on TNT,
It's,
TNT?
yeah.
Do you know?
we're ready,
No?
Pardon?
we're ready, we're recording.
Oh, we're ready.
We're recording,
Oh.
okay, well, we're waiting for.
We're waiting for-
We're waiting for the management.
Is all this being recorded?
Well, let's go ahead and get started, Jim.
Okay.
Just for the record, we're back from a short bio break, and we're now getting into the conditions as proposed by staff. And then we'll have any conditions.
Yeah,
proposed by-
we're like the stock market. We're like the shoulder. You know how the shoulder? Georgia,
South Carolina, Texas A&M, Alabama.
We'll be
We're
close.
still talking. Oh, sorry.
Okay, recommended conditions of approval are on pages D1 through D4 of the staff report. And the basic format of the conditions of approval is the format that we're going to be using for all site plans. So there are some subjects that are not addressed specifically in these conditions, but you can just see how the format will be presented in the future. And rather than run through every specific condition, I think I'll just hit the highlights, if that's okay. Under the heading of general, and I think this addresses one of the issues that was raised at the meeting today. Number 2, landscape service use is approved as an accessory use and shall remain operational only in conjunction with the wholesale nursery principal use. And then condition number 3 really relates back to some of the waivers for requirements that we granted. We granted those requirements primarily because certain activities were not going to be undertaken, certain construction-related activities were not going to be undertaken, so we waived all of the application requirements associated with those activities. And condition number 3 essentially said,
When you do that, does that mean that that is now not up for discussion? Or can this body say, we disagree, that should not be waived? And I realize that you, as the town manager, have the right to do that. But I think ultimately the decision as to, in this case, because it is so unusual, should really be the town council. Is that, or?
Well, the way the process works in the application format, Jim is, I'm not trying to, Jim made the recommendations. And I looked at the application and his rationale, and I agree. That's, our process does allow for that. Does allow for waivers of some things that, might not be perceived to be applicable. Or in this case, I think we did have a provision that they could have to come back.
yes.
So that was felt to be appropriate enough.
Yeah, that's essentially what this condition number 3 is.
Yeah.
Is that if any of these activities are undertaken.
But I'm stuck on landscaping.
Yes, I know.
Okay.
I think that we had a discussion during the break, and we may have a solution to that.
No.
Well, D2, on page D2, Jim, if you look at number 3.
D1, he's
D1, yeah, attachment D of the staff report, page D1.
What is the procedure for the approvals in the 3?
The procedure for the approvals?
It says you can't do any of those activities without obtaining the necessary approvals. What is that procedure? Approval
Prior
by
to the
the
issuance of
town
building
manager.
permit.
No, it's, whatever permits are required, in order to undertake those activities, they're gonna have to get those permits if they undertake those activities.
Probably a site plan.
I was gonna say, some of them might even would require site plan amendments, perhaps. I mean, in a new building, a sign that is not part of this approval, are just two examples that I can think of which would require some, and then some of it, like maybe existing vegetation will just require a permit from, so, the point is that, I guess on this one here is just, it already, those conditions, those items, those requirements already exist outside of being a condition if they're gonna amend the site plan.
Right.
And for example, you were concerned about landscaping, remember Joyce, if you look on D2, the third condition there is prior to the issuance of any future building permit, the property owner shall submit a landscape plan to the town of Waxahachie Groves for review and approval.
So anyway,
All right, Jim, go ahead.
The only engineering condition was generated by Palm Beach County as a result of the traffic study. And that condition is that no building permits for the site may be issued after December 31st, 2013, unless a time extension. That was based on the results of the traffic study. That condition imposed by Palm Beach County traffic division. Okay, page D2, the land clearing activities.
Jim, I have a question on D1, number 3. Very bottom, it says the property owner shall construct the following. I don't know what that means. Construct what?
As I said in the beginning, this is like a general format.
Oh, okay, I see what you're saying.
So that's an item that's going to be addressed on all of them, but it's not applicable on this one. Okay, under land clearing.
I'm sorry, if they were going to do a screen that was other than vegetation for the debris pile, wouldn't that be something that would be put under here? If they were going to use like a physical screen that was constructed as opposed to vegetation? I mean, I think as part of the conditions of approval, we need to establish what that screen is. And then it becomes part of the site plan. So if it's what Chair Lip suggested and screen it from Okeechobee as opposed to trying to screen the physical pile itself, then that has to be part of the site plan approval because we want to make sure that that remains for its entirety of operation.
Yeah, well, I guess we might as well address that right now, because we talked about that during the break, and the applicant's willing to amend the site plan to show that screen.
Or some facsimiles.
Yeah, prior to it going to the council.
We'll have
So an entryway,
Yeah.
Right.
Entryway or
Feature.
something, whether it's along the road or entryway
Yeah.
or something, because we really don't want to put a hedge around our fueling station. That doesn't make any sense for how we use it.
No.
So there needs to be something there, and that'll cut off something.
plans to die.
And then we'll just need to rework the nursery area a little bit so that the vehicles could go around the screen.
That's true land. Okay, good.
Okay, under land clearing, any land clearing activities must comply with the Waxahachie Groves Native Tree Preservation Ordinance. Number 2, the existing vegetative screen along all property lines shall be maintained. And,
Well, in that, never mind, we're going to do our,
And if there's, are any future building permits required, a landscape plan must be submitted to the town.
Can I just ask you clarify one thing, that
Yeah.
a number of these things are triggered by building permit, could we say building permit for vertical construction? Because if we have to put a concrete pad for the dumpster, I don't want that to have to trigger everything.
That's fine with me.
That's good.
Okay,
I didn't catch what he said.
okay.
What, just as clarification, what when I heard them say if they have to put in a pad for the dumpster, that's not gonna require a building permit. It's only for vertical.
But we require a building
It
permit,
will,
but not a
but it won't trigger
landscape
it.
plan.
Right, and once we trigger all these
Yeah.
things.
Because they're always-
Okay, down to use limitations. This
I like something on exterior lighting there, Jim. I'm serious about this. Your lighting is not in compliance with ULPC. Our lighting requirements in the town is that it all be focused down. You have a spotlight in there pointed at the church across the street. And so we have to have the town's lighting, ULPC, be applicable for the site. Because we can't have, I mean, it's basically, take a light meter, and if you're, getting more than background lighting at night, then it's a code violation.
I'm sure, as a, not dealing with this, but I'm sure, I can work with Bev and we can make sure we get that without having a violation.
It's pretty straightforward. It's in the LGC, it's lighting is down, not out.
Okay.
So you want it, rather than not applicable, you want it
As per town ULBC.
comply with the ULCC.
But is that gonna trigger that in terms of parking areas need to be lit?
Well, parking
It's less
areas can be-
restrictive than what
can
you
be
have
lit.
now.
Well, that's true, okay.
Parking areas can be lit with, with downward focused,
No, but what he's saying is, we don't want to have a requirement to have to
Oh, no.
go light the entire site. kind of thing. You're just saying there's spillage
Yeah.
over that we need to address.
Okay, on training, parking lot, loading, signs.
Yeah, yeah.
Use limitations, okay.
Yeah, use limitations, that's where we attempted to address the issue of the vegetative management plan.
Okay.
And we looked at vegetative waste storage and processing. We have several sub-conditions under that item. The first of which is that the only vegetative materials that can be stored on site are those that are generated by either the principal or the accessory use. And
I don't quite get the outdoor storage of debris is prohibited.
any outdoor storage of any debris other.
Could you put in there construction debris or, debris are pretty big, so if it's construction debris.
Well,
not
we're saying
construction debris.
We're saying with the exception of vegetative waste generated by the wholesale nursery and landscape services, all other debris is prohibited.
We'll put in there all other
Okay.
debris is prohibited.
For all other.
I've got a question on
Problem.
the debris. And I'm playing like the antagonist. What if they were to start bringing in horse shavings and mulching up? Would that be in violation of the, or could they do that?
Well,
If their landscape service started bringing in from Wilmington, the horse shavings, the horse manure, and they were to run that through the mulching operation, would that be okay?
I would say no.
Okay, I just didn't know if the
Yeah.
wording
Yeah.
allowed it, because they could bring it in, and they could mulch it, and is that?
But I guess that's not veg, you're talking about forest manure?
Well,
You're talking about other
rake up-
organics, other.
Yeah, you rake, let's say you go to a horse, you're doing landscape services at an equestrian estate, and you rake up all their mulch in addition to the tree trimmings. And to me, this is a ruse. You know, what you're really doing is taking what they want you to get rid of and mulching it up on your site and dumping it.
As far as I know, in order to be a shavings hauler in Wellington, you've got to be registered with the town and with Wellington to pick it up. So these guys coming in.
I can assure you, we're not going to be doing that.
Okay, and I'm wondering, could anybody do that, you know?
I understand your question, I'm just clarifying, we're not going to be doing
You can put in no horse shavings.
I don't know, maybe you put in horse shavings.
Okay, see,
Okay, item B really just sort of summarizes the entire operation that's permitted on the site. Consists of solely of importing, grinding, and on-site use or licensed off-site disposal of materials. The applicant has indicated that all of it is going to be used on site. But we added this condition to address the possibility that at some time in the future they might need to dispose of it off-site, and if so, it has to be disposed of at a licensed facility. According to the applicant, that will not occur, but we wanted to address that possibility. Fees shall not be charged. Item C, item D, really addresses the criteria that fire rescue requested that we incorporate into the conditions at the initial meeting we had. Maximum of 15 feet in height of the pile, minimum 20-foot clearance provided for emergency and fire vehicles. And the limitation of 90 days wasn't really a fire rescue concern. We put that in there to address some of the discussion that occurred at the meeting in November regarding the possibility of fires being generated by the piles. The fire rescue doesn't have any criteria there, but we put the 90 days feeling that was a safe limit to ensure that fires, possibility of fires are minimized.
Jim, I have a question on that. You're saying you've limited it to not, they can't do it any more often than that? What would be the reason for that?
No, we're saying that the pile cannot stay there longer than 90 days. That's
Okay.
what that's supposed to say.
Okay, and so I figured out that you've got 1,000 square feet of area devoted to this pile, and if you didn't allow it any more than 30 days, you could reduce the size of that pile to about 20 feet by 20 feet. Just comment.
Okay, when the site plan originally came in, they had a vegetative area at 100 feet by 200 feet, and working with the applicant, they agreed to reduce it to 100 feet by 100 feet, which will allow them to comply with the setback requirements.
It's trying to also balance, I think, the number of times that we shift, because obviously that could be noisy and we want to minimize that. So I think it was
Week and a half, you don't want every week and a half the neighbors waking up to the sound of the grinder.
That's what we
Well,
don't
next
want,
door
right? So we're trying to do it
neighbor
quarterly.
is a grinder.
Oh, really?
At the corner of Edmund Okeechobee is a huge mulching grinding operation that's non-compliant and illegal.
There's also one at Effin, Okeechobee.
That is a Edmund Okeechobee. That's-
Dean Okeechobee,
Okay.
on the southwest corner.
Yeah, Dean, I think we started an MOB on that.
So, so I think the fact that, it's being done anyway,
chipping and mulching, item F, is going to be performed by what's termed a vertical grinder, and I guess that's the type of grinder that is the most environmentally sensitive. And it can be performed on an as-needed basis, but it cannot exceed a maximum of 4 times per year, and it has to be done during the hours of 9 to 5, Monday through Friday. And the grinder shall not be permanently located on site, rather brought on site when it's needed.
What if the pile gets over 15 feet high after 60 days?
About the haul off. Yeah, or you grind it, or we'll grind it. We'll meet that, those are the restrictions, 90 days or.
Yeah, but if they limit you to a maximum of 4 times,
Let me ask just a sort of a technical question that I'm sure that Harm might have the answer to, is that one of the concerns that we on the board have, and I'm sure the town council will also have, is the importation of exotic diseases, like white fly. You know, I've got white fly in my palm trees now. This guy raises palm trees, and it's an expensive disease to get rid of. Is there anything that you can do as a landscape company proactively with the debris that you bring in, with some guys with sprayers or whatever, to treat all the stuff you're bringing in so that there's not going to be any exotic bugs infecting our town?
That's a question that's not within my expertise, but I will definitely get you an answer to that. And however, we can get that to you through Jim.
Yeah, I mean, that's something that I would ask that you put in there as a condition.
I don't know what can be
I don't know
done.
either. Rob, do you know anything about that?
And I thought about that, and you still have the same problem with the nursery, they're bringing in material, and it could happen, because I was like, that's really sad, because I think that the white flies we have now is from importation of cut material. And but not to say it wouldn't have happened anyways, because nurseries are bringing stuff in from other areas wholesale, and everybody doesn't just grow from seed, and it's gonna happen.
I'm a victim of the citrus canker. I had 60-year-old orange and grapefruit trees over my driveway until Charlie came, and with them getting all the debris out, they brought in waste like that. So I understand your question. I will ask to see if there's some treatment or insecticide that we can spray. We do have insecticide licenses for all the pesticides and insecticides, so I'll ask that question to see if that can be
Something you
included in
can
our
do
maintenance plan.
proactively, you know, because it's going to make it a lot more palatable going forward.
I appreciate the comment.
Just to add to that, other communities have adopted white fly preventive ordinances, so, by practice, so.
Okay, item number 3, there was some discussion about this condition earlier. This condition was taken directly from the county's code, and I mean it would be in effect in any event, but I felt it was worth restating. And as is condition number 4. Condition number 4, I think, is something I took out of the town's code.
Well, barbed wire isn't prohibited. You know, it's more a livestock thing than a nursery.
Yeah, it is somewhere. Oh, okay. That is in the county's code. The use of barbed wire shall be prohibited.
I think.
if they don't have an objection to it, we should
Yeah.
just.
All right.
Okay, under utilities and services, okay, we're talking about screening of the fuel tanks, but we may revise this condition depending upon
If you
the design
can
of the
do
screen.
something across the front of the property
Right.
to,
It makes sense.
Yeah.
I like things that make sense.
Yeah, and condition number 2 is a requirement for a refuse container and recycling container, which they do not have on site now. And public safety, Knox box shall be installed. That was a recommendation of fire rescue, so that they could access the property at night if the gate was locked and there was a fire. And that's it, with the exception of compliance. It just has all the actions that the town can take if the site plan is not complied with or any of the conditions are violated.
Okay, what I'd like to do to put some goals for us for the rest of this meeting is if anybody has any additional conditions that you would like to bring that up as a motion that we can then vote on. And then once we get done with the conditions, I'll give everybody a chance to speak their mind. Please try to limit your comments because we've had a lot of talk about this, summarize things, and then we will, then I'll entertain a motion to either move to approve or move to deny. So anybody, let's start now with additional conditions that you'd like to see. We'll start down with Burns.
Okay.
Okay, Veronica?
Okay.
Explain what it is and then make a motion and we'll go.
For each one?
Yeah,
Just collect, what if you have like 10?
10, sure, let's do each one.
Okay.
Charge through them.
Let me go back to, maybe a little difficult, because I'm trying to work from his and from mine. The requirement in the town's code is 70% impervious area, is that correct? I would recommend that they be required to meet the 70%, can they meet the 70%
Yes.
impervious area?
Yeah.
I thought it was 67%.
Well, I think, let's see here.
64.6 is what's provided.
Can you meet that requirement?
Meet the town's
The
current,
70% impervious area?
that's a requirement under the current town, the town code?
I think,
But I thought we were talking about.
either one or the other. Well, we seem to be kind of cherry
Flipping back.
No, I
Yeah,
think
so
it should be, as far as I understand, this site plan, we were told to comply with the county code, and that's the staff's recommendation.
There is no requirement in this district for purpose area in the county.
So then going back to, we need to institute the county regulations for landscape buffer, not the town's 15 feet.
And the debris pile.
And the debris pile, which according to the county standards is not allowed outdoor storage.
So I thought we were trying to meet some kind of happy compromise here.
If we could.
Well, the minimums are the county code. I think is that maybe I'm missing the dynamic, but what I was trying to get at before is whatever could be done to bring it as close to compliance, what town requirements could be met. Above that would be,
So it's 70% under the town, so maybe, we're pretty close, maybe we can do
Pretty
it.
close, and I thought maybe if you,
Yeah, no, I think if we could, work.
Boy, how many square feet is 5%? Can you figure that out? How much total we got? No, how much total? 142.75. No, that's pretty small.
it's about 15,000 square feet, right?
That's a lot of feet.
To get to 70 from where they're at. give or take, I'm not a numbers person, but I'm just
Yeah,
thinking like 1/7 of maybe 11,000 square feet. Just doing 1/7 of 35%.
Yeah, that's 12,000.
Yeah.
Well, purpose parking can be grass.
But the only thing we could remove, I mean, other than structures, the only thing, there's just a covered, I mean, a concrete patio on the back of the office.
Well, maybe we can ask James what he included in that. I know his area calculations. I mean, whether or not he may have included the yard storage area as impervious, and it's been reduced by half.
Yeah.
So
It says here, the impervious area includes gravel driveway and all structures.
What does our code say about gravel, Jim? Is that considered impervious or not impervious?
it's.
Yeah, but there is some coefficient too of impervious. You know, so if you did that, like 0.8 instead of an even 1.
Okay.
You
Well,
know,
let's.
Okay, well, why don't I
don't
just
think
phrase,
we're gonna
why don't I
resolve
just
it
phrase it,
now.
right, okay, so I'll just phrase it this way. My motion would be to recommend to the town council that you provide 70% pervious area, and whatever you end up with when you get before the town council, you all can discuss that. That would be my motion.
Is there a second on that?
Second.
Okay, any further discussion? All in favor, all opposed? Anybody opposed? No.
All in favor, say aye.
Yeah, all in favor, say aye. Okay.
Went a little too quick there.
All right.
Yeah.
Trying
I know.
okay, so that, add that, Jim, good?
It's a recommendation.
There's a recommendation of this.
Okay.
Okay?
I want to make sure I understand. No building, we have a site plan that has existing buildings on it. There's a requirement that you can't get a permit to do any other structures until after 2013. You can't get permits after, unless you do the traffic concurrence here, so is what it was.
Unless you get an extension or redo the traffic.
All right. So if they added additional structures, that would increase their nonconformity to the town's pervious area, is that correct?
But based on the percentages we have here, yes.
So my motion would be to not allow them to increase the amount of impervious area by the construction of new buildings.
Okay, is there a second to that motion?
Could you repeat it, please?
Could you repeat that?
That they not be allowed to increase the impervious area on the site because it would increase the nonconformity. They might not be allowed to do that anyway, actually.
Yeah, I mean, if there's,
It's
yeah,
gonna be legal
Yeah.
non-conforming.
right, so that, I mean, you can put it in there, but it's like the other ones we talked about, it's
Yeah.
already there.
Okay.
So you're withdrawing your motion?
Well, if there's no second, I can withdraw.
Okay. All right.
I have a condition here, specify the maximum number of employees, because I understand that the drain field is sized for the existing number of employees. And if there were more employees, that would mean that the drain field is insufficient.
Yes, it's tricky because the number of employees and the total number of employees that arrive on site, only 2 out of how many total? 30? Remain on site all day, so the 90% of them are in and out.
The drain field's actually based on the size of the building, is how it's done, it's per square footage.
Yeah, they're going all day. Okay.
Yeah.
It was also based
I
on
would-
residents, not commercial.
I'm sorry, what was that?
I was wondering if the septic tank size was based on residential, when you said it was originally a single family residence versus the requirements of a commercial
Yeah.
facility.
The It's still, the report that's in there still is based on the square footage of the office space that is the house, and it's a compliance.
But commercial use is a different department.
Commercial and office? Yeah, that's what it's based off of.
So it's
Okay, but I'm saying, was that septic system put in, when it was a single family residence, or was it put in as a, for
It was
commercial?
put in, but there was a report given that was included here that says that it
Okay.
Well, the report said that you needed to replace the septic tank and repair the drain field,
Right, no, we do need to repair, but the size of it is sufficient for
but
use.
that's not in here anywhere.
The size is sufficient, does meet the standards for commercial use.
Yes, but it does need to be reported.
So you just need to have some, do you have like the documentation that can be supplemented for that, for the council review?
Yeah, I think it's, let me check to see if the report's in here.
Yeah, we have.
And so it can be included in the package so the council verify that.
Yes.
Okay, I think you should, if the debris area is approved, I think the screening should be defined. So are you thinking that if you screen the perimeter of the property, there won't be a requirement for screening the debris pile? Is that what you're saying?
Correct.
Okay, then in that case, I would specify that the screening of the property has to be at 100% opaque, maybe 8-foot high hedging, or something like that.
I will forward read this.
Well, I don't want to specify what plant material, I just want to say what the standard is.
And the screening is just where the
Well,
opening is.
If you say that, then all I'm gonna say, I'm gonna screen the pile. I mean, because why would I screen the entire frontage for 500 feet when I can screen 100 feet?
My
It doesn't make
understanding is
sense.
it's just for the opening off of Okeechobee.
Right.
And there's screening.
Well, I think I think your landscape buffer between, the street and your property, I think that's got to be beefed up. It just can't be
Well,
a bunch of four.
Well, there's a couple of things going on here. I don't mind working with you to make sure that we're accomplishing the same goal.
Yeah.
But when you start talking about 8-foot solid opaque that you can't see through, you're talking about hundreds of thousands of dollars to go all the way across the road, and you can't do that. You would go to, hey, I'm gonna screen this 100 feet of pile. So,
Yeah.
if you trust us and work with us, and we can show you what we can do and screen it, so,
Well, I'm a firm believer in trust but verify.
I'm a Ronald Reagan guy myself.
So-
That's fine.
I thought that, wasn't there a requirement that they have to screen the parking area, which is half the property?
But screening parking is 40 feet or 40 inches high. That's not gonna hide my pile.
Parking area, the requirement is 40 inches.
I wouldn't say that.
You wouldn't-
I wouldn't say that. I mean, without having a copy of the county's,
Can you show me a parking lot in the county or anywhere else that's got an 8-foot high opaque all the way across? It's not gonna happen.
I'm just throwing that out, so.
No, I understand. I'm just saying, I'm willing to work with you here, and I'd like to get you happy at what we're gonna do. But if you tell me something like that, then I can't do what the chair was trying to talk about, where we can screen stuff that's mutually beneficial to us and to you. You don't see us, we go away.
What
and
height do you think is
we don't
appropriate for
care.
along the front of the property line, Mr. Chairman?
Well, I think if we look at properties up and down Okeechobee and other areas, probably something at least over 6 feet. So when you're driving by, you don't really see the buildings back behind. That's why I recommended, because I've got I've been blessed with a very difficult neighbor to my west. And it certainly has tested me, and I found that the best opaque screening I had was Aurigas. And because they tend to replant themselves every year, and they just keep growing thicker and thicker and taller and taller. And so I'm not bothered at all by his 3 diesel trucks that he starts up in the morning when I still here. But anyway. you know.
Well, what even goes better is plants on a berm, so
Yeah.
that you can't see through it, and
Yeah.
it gives you a good sound barrier. But until I can go back, talk to my guys and see what we're doing, I can't say that right now.
Well, then why don't we just say 100% opaque, 6 feet? Can you do that?
Along the whole border, or I'd rather leave it open to the screen and have some provision that, you know, we get with staff or code enforcement or something that, I don't mind there being a check on it so that we can make sure everybody's happy. I just don't want to say I'm going to go all the way across the front, that we've got to do something
Because
that's just astronomical.
a portion of the front is gonna abut the nursery area, so you're gonna be seeing green into the nursery. I think it's gonna be mostly trees, right?
Yeah.
So, perhaps we can just work with staff to make sure that Okeechobee is properly buffered.
If you go to B10, underneath buffering, it talks about in the county code, accessory and temporary uses, and it actually includes your nursery type materials, but to a very specific location. Grown in the ground, 10 feet on center, 6 feet in height, and the growing area must be at least 20 feet wide. Width of the
What page
buffer.
are you-
It's on B10, under R, buffering. So I mean, I, with all due respect, Jim, I know this is really complicated and we're pulling things out from everywhere. I would not agree with you guys that this is a clear cut. He's established why this should be approved, because I don't feel that that has been done. I don't think this is, you know, substantial and competent evidence that this should go forward with an approval, because there are things in here that clearly state what can and can't be done. There are buffering requirements that are clearly stated in here that pertain to accessory and temporary uses. There's stuff that talks about you can't have accessory buildings, you know, within the front yard. We've got that here that hasn't been addressed anywhere. There's a lot of things that trying to get to the resolve we've overlooked.
I think the thing is that if you just keep in mind, you know, if you go east on Okeechobee from your location, there's a new church that has been built around an old existing structure. And you really don't see it until you drive by the driveway. You get a little glimpse, you know, if you are intentionally looking, because the rest of it's very effectively screened. It's screened with Brazilian pepper, but it's still, you know, effectively screened. And, you know, and that's just how it worked out for that particular church. You know, so I think if you know, put your mind to it, because what the community, number one, see, you know, we're in this whole thing right now of what is Okeechobee going to look like. And if we have a clearly industrial use, accessory, but it's clearly an industrial use on Okeechobee, well, then that's going to, you know, add flame to the fire of, well, then why can't I do the same thing? It's going to happen whether or not it's unique or precedent setting or whatever. It's going to be a problem. However, if your place looks like, you don't see it. Number one, you don't need to advertise, you know, that you're valet rest. You don't need a blinking sign. You don't need, you know, to draw a lot of attention to yourself, because you guys leave at 7 o'clock in the morning, they come home at 5 o'clock in the afternoon, and they're done. So if you can effectively, out of sight, out of mind, you're going to fit in with our community.
What is your preference? What would you like to see along our road frontage?
Like in front of the church, except for not Brazilian pepper.
No, I'm saying, what would you be,
Well,
are you saying vegetative or a fence? If it was a fence, would it be chain link with scrim on it, or would it be,
No, it would be.
or would it be PVC vinyl, or what, say again?
I'd do the plantings. Plantings is a
Plantings.
natural, plantings would be a natural rural feeling. Any type of construct
That looks
blind is going to look like a blind, and we don't need that. We need a natural setting.
And-
But you're saying at what height?
Well,
you're saying 6 foot high?
It's 6 foot, 100% opaque. And I don't care how you do it myself.
Right.
I don't care what you use. That would just, I'm just throwing that out as for consideration.
What's the line to the property line?
Well, and how much time would it be for it to become opaque? Because sometimes
Right.
it grows 40,
Yeah.
because it's 10 foot on center, it's never been grown.
No,
I've got a fence all the way across there. You know, if you want just 100% opaque, I can just grow vines. I can plant vines now, and if you say, hey, I'm watering them, they're gonna cover the whole thing, and you're never gonna see me, and I go away.
Do we have anything in the code that addresses if you put a fence along?
Well, I already have a
100%
fence.
opaque.
The fence is already.
The fence is already there. If anything, I could get a, you know.
Yeah, but it's not
maybe-
acting as a buffer. You can see right.
And honestly, I mean, for us not to get burglarized, we like to have some visibility in to see if anybody's coming across there. I mean, right now, we park our trucks there across the 2 gate entrances we have.
Oh, what does anybody else think?
Are you done?
Well, no, I'm just wondering what the thoughts are of anybody else. I threw out 6 feet, 100% opaque.
Well, I think when you get into 100% opaque, you're running up the cost, because then you're looking at berms and bringing in hundreds of thousands of square feet of fill.
Oh, no, I'm sorry, I meant just by hedging. You can get 100% opaque, and you can go down to the town of Palm Beach and drive down any road, and with one ficus hedge, you're 100% opaque. So you can't do it.
You grow in over 10 years.
Yeah, you can do it.
Typically, I think how it's done is you require the height of the tree at the time of planting, right? And then ultimately it's going to mature and grow. So if you want,
And maybe we specify how
I think
long
if you
before.
stick in a bunch of plants that are, 4 feet tall,
it's going to be
and then, but the characteristic of that plant is gonna grow,
Yeah.
and being a landscape company as well as a wholesale nursery, I'm sure you have the skill and expertise to do that.
And why don't we just say minimum 4 feet must grow to 6 feet within 2 years? I mean, you can do that with the ficus, I don't know about other stuff.
But that ficus brings in the whitefly issue.
Yeah, so I mean, I don't know about.
I like the
I
original.
think the reason.
I have it in my house too.
Arena's work.
But
You can put 6 foot trees in.
So 4 foot is the time of planting?
well,
I'm not saying we agree.
Yeah, yeah.
Some discussion.
I'm just trying to figure out.
Well, really, you need to gear it towards the landscape.
Well, I mean,
So that's only half.
a lot of ours is probably gonna be, we can berm, build a berm, put some plants on top, they don't have to be 6 foot tall on top of the berm and everything. But I don't wanna say tonight, but we're definitely, I want some interaction, so, and whether that's through staff or whatever, that we can come up with a resolution to say that, the fuel, the dumpster, and the pile are screened from the road.
And the parking.
Should be.
And the parking.
The landscape maintenance vehicles is what you're.
Your parking area.
Per parking
Yeah,
area.
well,
Landscape.
there's nobody there at night. I mean, that's only, I mean, I'm trying to figure out what you're trying to screen from.
The code requires that it be screened from the right of way, from public view. So.
All right, let me make a motion, because I don't get the.
Okay, let's move on.
The motion would be that they be required to provide 100% opaque screening by whatever method, minimum 4 feet to reach a height of 6 feet within 2 years. But how do we feel about this? Because I don't particularly see fence. You understand where I'm going?
Yeah.
Landscaping buffer, let's put it that way. Minimum 4 feet and time of planting to reach a height of 6 feet whenever.
I think we're shooting for the desired result.
What we're saying now,
Just-
we get rid of my buffers. If I put up that, then I don't have any buffers.
I don't have a problem with eliminating the requirement for the buffers of the interior stuff.
If you can't see it from Okeechobee.
Yeah. But my motion is to require that, and if you want, I will add on to my motion
Although,
that, what?
what about the property owner to the rear? Is there anything that they would then require buffering from?
Yeah, sure.
There's vegetation and a wood fence.
Okay, so there may be buffering existing.
Right. It seems like on the own that,
Okay.
So then, and they are allowed to use existing buffering in the rear as long as it adequately screens the
Mhm.
structures.
And along the front, we don't, I mean, the nursery area, let's say, I guess that's the northwestern portion.
Is so bad, that's the worst
But that's
section.
where the tree farm
All right, that's my motion. So,
But to
that's the
exclude that area
recommendation
where
of
the
the
tree
council.
farm is gonna go?
Pardon?
In other words, if this area along the northwestern part is going to be the nursery with rows of trees, we do not need to provide the buffer along that area.
Yeah,
Because
that's
then
true.
parking is
This
not
is
here.
here.
As long as there's no parking over there
Right,
like
no,
there
it's
is
gonna be
now.
the nursery, the plant, tree plants.
Okay, because earlier I thought someone said there could be parking
Could you
anywhere.
just
Yeah.
repeat that so I make sure I get it?
So I will change my motion to say along east of the entryway, full 100%, starting at 4 feet, ending at 6 feet or more. And anything along the west? Landscape training, yeah. Anything along the west at all. And the rear can use existing as long as it's sufficiently opaque to screen.
I would fill in buffer on the west end. I mean, you can clearly see gaps. I drove by there today specifically,
Where though, what portion?
on the western portion.
Well, that's because there's no nursery there yet.
They're gonna put a nursery there.
He's saying that with the nursery.
I understand that, but if there's supposed to be a requirement of a landscape buffer adjacent to the right of way,
Yeah, now what it says here,
Oh.
if the nursery has trees 50 feet in depth, it doesn't meet the buffer.
right, I pointed that out, I know that.
And if the nursery has,
Incompatible buffer.
anyway, that's my motion.
And then the rear property.
And the rear property line is existing vegetation as long as it's screened. Provides adequate screen, and the town can interpret that.
I would second that.
okay, so we have a motion on the floor for adequate screening, vegetative screening to the east of the entryway and as may be required, I guess, on the west side where the nursery is scheduled to be. And then something on the inside of the entryway that would screen the interior, some sort of a, behind the gate, sort of entrance. Yeah, an entrance.
Friendly amendment? Friendly amendment? Can we just say something to the effect of, with your motion, vegetative, man-made, which would be fence, or a soil berm?
I myself don't have a problem with the soil berm, but I do have a problem with the fence.
Yeah, 'cause
Whether the fence is existing.
Yeah.
And it's not sufficient, I think that's the point, so.
Right, but I'm saying that there was another fence put in that place.
I would prefer to see either a berm or landscape. A landscaped berm or,
The landscape berm would be good with me. I think when we start getting into the fence, your comments of the chain link with the vinyl strip running through it is like this. Fingernails on a chalkboard. So I think in the free-flowing discussion, certainly a berm. But you're going to put a security fence in anyway.
Right, but yeah, we already have the existing security fence, so we just need something to further make it opaque to have this.
Just cover it up. Okay, is there a second on that sloppy motion?
I thought I seconded it.
Okay, great. Any discussion from the board? All those in favor, say aye.
Aye.
And opposed, say no. I guess we're good.
next motion, any additional building must be observed the 50-foot rear setback.
That would happen.
That would happen.
County's setback was 25 feet.
They'd have to adhere to the new standards, correct?
For new construction.
New construction.
Any new construction would have, okay.
Yes.
I would require a declaration of use agreement for all these conditions.
What's that again, Mark?
Require a declaration of use agreement to codify and memorialize this approval.
But is,
I'm not sure what that is.
well, why would you think you need that more than the resolution that would outline it all and perhaps have that just recorded?
Well,
I'm not trying to be, I just don't
no,
understand.
that's all right. I find that's a real effective document for enforcing kind of tricky conditions and things like that, rather than just a resolution, which, I don't know, we just use it as a more definitive documentation of exactly what's going on, and it's executed out there in the public record, in the property records, and so on and so forth.
So the next person coming in actually knows.
Sees it all and knows it all.
But you get the same thing.
You can just record
Recorded in the reso, but, I mean,
Yeah,
it's your
I've
prerogative.
been
I mean,
recording
I don't
the reso,
know what
that's
the
a-
document
yeah.
that, I mean, I'm,
No,
I
if the
have-
resolution's being recorded, then that's.
if you put a condition in the resolution,
Okay,
you record it.
recorded, yeah, then I have no problem with that. Motion, then my motion
At
is.
the, at their expense, because with all the conditions, they're probably about that big. We don't want to have any confusion about cost recovery, so.
Always protecting the town.
Absolutely.
Did you want to make that motion?
That you
Yeah.
want to just,
My motion is to recommend to the council
I mean,
that they record the resolution.
I would think that would be good SOP for us anyway, but I put it
Oh,
in a
okay.
condition, and that way it gives us a place to start. So, yeah, I would, go ahead.
And
Second.
Second.
All right, all those in favor?
I,
Those opposed? Okay, 5-0.
I talked about this before, I'm not sure how we resolved it. My motion would be to allow operation of vehicles, no operation of vehicles prior to 7 a.m. and allowed through 7 p.m.
That was for over 1 ton. Correct.
Pardon?
That
All
was for
vehicles
over 1
or-
ton, That was the diesels over 1 ton.
Right.
Yeah,
The
yes,
one-ton
restricted to
vehicles.
vehicles over 1
I think Grace,
1 ton or more.
I think Grace, at the last meeting, you raised an issue with trucks coming out with rush hour traffic, so it's
Yeah.
a balance, you know, if we start earlier, we avoid some of that. I don't know, it's just-
And honestly,
How
we
many
haven't had-
one-ton trucks do they have there, do you know?
No, I mean,
Yeah.
we're only running about 10 vehicles in and out of there all the time anyway. I mean, this isn't high volume.
When I believe the specification was over 1 ton.
Right.
Yeah. And that didn't specify diesel, which is what you were worried about.
Yeah, I'm worried about the diesels.
And it is a 5-acre site, so
Yeah.
somewhat.
Oh, what's the board feel about that? 7 a.m. is too late?
I think 7 a.m. is too late because
Yeah.
the traffic's picking up.
School buses are all over.
School buses are over there. If they can get their
Vehicles out.
their maintenance guys out by 6:30, I think you're better off. You know, but that's, I think we're getting too deep in the weeds on that, certainly.
All right. I think that's all I have. I had one other, but I
You're
don't
not
think.
ready?
That one won't change.
Huh?
There's no motion on that one.
No motion on it.
There's no motion.
And I don't think that, I'd be interested to hear what the town attorney has to say about this, but I would add in the resolution, adding provision that if certain provisions are violated, and I'm concerned about the principal and accessory use, that if they're found in violation by either the town council or the special magistrate, that they agree to pay a fine of so much per day, and put it right out in the resolution.
But that's, the code enforcement system already has a set of fines, right?
It does, but
There's
I'm
a,
also recommending that we,
the code enforcement is $250 and $500. $250 a day for the first, $500 a day for repeats.
And isn't that set by statute?
That is, it's a code enforcement matter. It's outside of outside of chapter 162, but
Mike, does
I just haven't seen it.
does code enforcement actually enforce, like development agreements and the resolutions and conditions of
It
approval?
can be referred to code enforcement as a violation of the site plan. It's a cost-effective way of getting compliance.
Okay.
I know that one of the things Jim has there is a revocation of site plan. I've not seen that occur, but I would assume that would be a similar type hearing, like a quasi for the council as opposed, but that would be something for Rich, perhaps, maybe if they agree to pay costs of enforcement or something, but that's in our code too for cost recovery.
But is there anything prohibiting the council from adding this?
Well, except for the fact that it's not, unless they agree to it, it's not one of the listed criteria for site plan approval that it's an over and above type thing. There's no provision in our code for establishing a fine for that. If we had something like that, it might be something I feel more comfortable with.
And my last one would be to make a motion to limit the size of the pile. I would suggest 20 by 20 with more frequent chipping.
But then we're, again, it's the balance. More frequent chipping means loud noises and disturbing neighbors.
I know, but a bigger pile, more infestation of whatever, and more roadies, and more noxious fumes, and so on and so forth. Anybody have any feelings about that?
Well, we have a chipping mulching operation literally next door. We also have one across the street that's very well shielded, the Choquette hauling operation.